to greet you. I'm glad to greet everyone who had a good sleep, which is a rare case. So sometimes people are spending their nights in metros and shelters. Soon we will have the drums and shelters, those who know those cave things, but I think that from the beginning of the full-scale invasion, the whole country studied various names of weapons, Patriots, Leopards, MiG-31K, hopefully it will fall soon, Buks, Grads, and so on. And this is more or less modern weapons. But one more bad thing is that young women, men, children, elder people in our country faced the ancient weapons, sexual violence that Russians brought here and are using as a weapon. So how to prevent this? How to draw to responsibility those who are guilty so that each person gets the right for their satisfaction in court? We will talk about that not only in the context of war, but also in the context of peace, because unfortunately sexual violence and gender-based violence still remains relevant and, so to say, hot topic in our country. So let us begin. And now to the greeting word, I would like to invite Ms. Katerina Levchenko, Government Commissioner for Gender Policy. Ms. Katerina, the floor is yours. Hello, dear colleagues, dear participants. I am really happy to participate already the fourth time in the Forum of Women Lawyers. And I see more men here, and this is a tendency which I also observe every year. It's a huge and very important event, but this event is important for us because today, the front lines, there are our defenders, women defenders and men defenders who are giving away their lives, their health for Ukraine to be independent, free, and the country where human rights and rights of women are respected and implemented. Therefore, I offer to begin our forum from the minute of silence in memory of those who died. Thank you. We all have losses, but nevertheless, we all came here today for this forum of power. And I wish all of you that today's communication inspires you for further work and for you to have powers in order to think about those important processes that are happening today in Ukraine. I also understand that today's forum is a forum of unity for us. Unity of different people, unity of various legal schools, unity of different NGOs, activists, men and women, all of those who came today and who are members of this big organization, which we call URFEM, and which became a reliable partner of the government and myself as a government commissioner in all the programs and all directions of work that are related with ensuring gender equality, its implementation as a principle informing state policy in any field. And therefore, it's great that you are specialists in different fields of right, of justice, because today we are activating international humanitarian right, and this is one of the most important topics of our today's meeting. It's very relevant: constitutional right, administrative rights, civil, family rights. I won't enumerate all the fields because without this, without rethinking, reconsidering of the situation. And without the roadmap, it will be incredibly difficult to build the new Ukraine. I also understand that today's forum is a professionality forum. You are all professionals in your work. And it's very important that this professionalism shows up in certain legal drafts, in your activity, in the steps that are making Ukraine closer to European community, to European Union. They are making us closer to NATO, and they are making us members and approaches and legislation to determination of the status, rights, and further actions that are going to be related with that. We can see today that there is necessity in strengthening this part in all directions of state policy, because when we are talking about reconstruction, we all understand that it's not about returning to the status or to the level in any field which we used to have before the full-scale invasion. We all want to have a new state, which is based on principles of being fair, gender equality, and so on. And those are not empty legal terms, but those are things that are showing up in the number of steers that are leading us to different premises and which can be taken by people with disabilities. And in Ukraine, we are going to have much more of such people than before. And today we also want to make a legal roadmap of work in order to prevent sexual violence related to conflict. I will have the opportunity to present you the activity which is happening from the point of view of coordination of state policy, and I will talk about that in my speech. But now I would like to mention that I would like to mention Ms. Victoria Litvinova, Deputy Prosecutor General. So Ms. Victoria, take your seat, please. Pierre Bassan, Manager of the program, together with the translator. Jay Totti, leading specialist on prevention, corruption, and right on development of democracy, mission of USA on international development in Ukraine, and Christina Kit, head of the Ukrainian Women Lawyers Association, Eurofem. Here you can give your applause to everyone. And straight away, I would like to give the floor to Ms. Victoria. Hello, dear participants of the forum, colleagues, lawyers. My greeting word today will be just like all the greeting words of the prosecutors, because we are used to that. It looks like a report a bit. So I'm asking you to listen to that attentively, because the topic that we are going to discuss today on our today's forum is incredibly important. The topic of our today's event is one of the most horrible kinds of military crimes that Russia is committing against Ukraine. Those are crimes of sexual violence. Almost 1.5 years, we already have the full-scale aggression from Russian Federation, and in that time we have enough evidence in order to say that sexual violence is one of types of weapons that they have. Those are not crimes of separate Russian soldiers. This is a policy of the country aggressor in order to destroy Ukrainian people. And in complex with other crimes, we are considering sexual violence crimes as an element of genocide on all the territories that were under occupation. We are seeing the same criminal patterns. Very often, occupants are committing crimes against those who have active pro-Ukrainian position. Very often, victims are members of families of military. And as it is known, sexual violence has nothing to do with the satisfaction of natural needs. This is a crime aiming to humiliate, aiming to dominate this is the attempt to humiliate the victim, and we can see that Russians are using that as a way of terror and in order to horrify Ukrainian people. We know cases when the commanders did not just not stop their subordinates, but they were encouraging such behavior and they were raping first. We see signs of systematic use of sexual violence against the civilians in Ukraine and against the captured militaries. As of today, we have 208 facts of sexual violence committed since the beginning of the full-scale invasion of Russian Federation against Ukraine. Out of those, 68 crimes committed against men and 13 against minors. Now, 61 facts of violence are revealed. And that is just a part of a horrible, horrifying picture, because sexual violence is a hidden crime, and it's hidden in two aspects. From one side, it's hidden in terms of the number of victims. Most of those are afraid to inform what happened to them. But the other aspect are hidden crimes as a character of consequences. These consequences are not obvious. For example, as consequences of shelling, it's hard to see them straight away and to notice. And these traumas remain with the survivors for the rest of their lives. And we can draw a conclusion that it's not one generation that is suffering, but the future generation as well, because in separate cases, children are witnesses of the crimes committed, and sometimes they already become the witnesses of the suffering of their parents, and they are worried due to that. Sexual violence is a trauma of families and even communities. Yes, communities, because we already have the documented cases when Russian militaries were raping citizens of the whole street when entering every house. In order to find out, to investigate these crimes in the Office of Prosecutor General, a specialized management unit was created on prevention of sexual violence related to conflict. And our employees are using modern approaches to addressing sexual violence related to conflict. First of all, this is ensuring provision of aid to the survivors and maximal protection of their rights. And also, this is avoiding of a secondary traumatization as a result of investigation, because only when the person feels safe, he or she can consciously take part in criminal procedure and provide explanations. With the aim of strengthening those approaches in practice for all the systems were amended. Development of prosecution for 2021-2023, and there are principles of Murat Code. This is a global code on gathering information on sexual violence. This code was developed by Nadia Murat, who suffered herself as a result of sexual violence.
By the way, recently she visited Kiev. So, in the basis of this code and its foundation, the key postulates that actually brought to this trial. This unit is acting proactively to detect sexual violence cases. Mobile prosecutors, investigators, teams go to liberated territories, and their task is to find and interview the potential witnesses and survivors. The members of these teams had special training. These teams comprise medics, also psychologists, and recently such team returned from Sumy region. In some settlements, they detected cases of sexual violence, seriously in particular. And they also detected at railway station, there was a torture room where people were held in carriages and basements, and tortures were used against them, including sexual violence. Taking into consideration the complexity of each case and different needs of survivors, those require different types of support. CRSV unit is coordinating this activity with the huge range of actors, helping to improve the methods of work. So we have a working group with 45 Ukrainian and international organizations as members. And this group also is designing protocols on how to work with CRSV cases and legislative amendments to be presented. We effectively cooperate with representatives of Verkhovna Rada recently, Marina Bardina, and the members of Special Commission, Temporary Investigation Commission. They designed a draft law to CPC of Ukraine on improving the procedure of pretrial investigation and court proceedings for this specific category of crimes. Last month, United for Justice initiative, in its framework of this initiative, we had a strategic session to generate joint solutions for CRSV cases. It combined a huge range of members. So we have the leading organizations, law enforcement, representatives of government, state institutions, and local self-governance. In fact, everybody who is interacting with survivors in that category of crimes. So the necessary managerial decisions to put this in practice, soon these were discussed with the heads of state institutions. During the discussion, respect, support justice. And also the ICC prosecutor Karim Khan joined us online, so we can see that there is a support for our efforts to investigate these crimes at the highest international level. Who also supports us, Pravo Justice EU project. Our experts are consulted by the global specialists on international law at all stages. The cases are supported. Global rights compliance helps with the methodology. Ingrid Elliott helps us to design strategic plan on how to investigate crimes of CRSV. Experts of ICC and Pramila Patton's office hold trainings for prosecutors and investigators. And by the way, I just want to stress that this cooperation is not a unilateral. Our prosecutors quite often have very unique experience, and they already share this experience with their foreign colleagues. Another important step to ensure protection of survivors and witnesses, establishing a new unit in Prosecutor General's Office Coordination Center to work with witnesses and survivors of war crimes. Who will be the personnel? Not the prosecutors, but those people who have skills on how to work in social area or who are psychologists, who have a psychologist degree. These people, coordinators, will support the victim or witness during the whole proceeding period. They will also coordinate efforts and needs of partners to provide timely and targeted support for these people. Formal procedures on establishing the center, we already completed these, and next week we will announce the recruitment for coordinators vacancies. So all these steps bring us to one big goal: ensuring justice and preventing the repetition of these horrible crimes. So for all of us, for all those who suffered, for the future generations of Ukrainians, and not only Ukrainians, because only if we punish the aggressor, this will be the best prevention for all the future wars and all future war crimes. I just want to express gratitude to organizers of the forum for this high-quality organization, for being involved in this specific problem. Thank you for still keeping this issue in your agenda. I really want us all to have productive cooperation. This
Забороняє всім своїм посадовим особам і працівникам і працівницям вдаватися до або підтримувати практику сексуальної експлуатації, будь-то на робочому місці чи поза робочим.
It means that we can lose our job and also that we would be given to the justice system to be prosecuted.
Це означає, що якщо таке трапиться, то, по-перше, людина втрачає свою роботу, а по-друге, вона стає об'єктом кримінального розслідування.
Don't get me wrong, I don't advocate for prevention over sanction. I'm advocating for prevention and sanction.
Але я хочу, щоб мене правильно зрозуміли, не йдеться про вибір між запобіганням та покаранням за можливі порушення, йдеться про запобігання і покарання.
The OSCE brings quite a support to the justice system in Ukraine through training and legal aid and also training to the judges.
ОБСЄ підтримує ці реформи в Україні, в тому числі законодавчі і правові реформи, зокрема через навчання, які ми пропонуємо і суддям, і іншим професіоналам галузі юстиції.
And we mainstream gender equality throughout our project.
І у всіх наших проєктах, звісно, ми інтегруємо гендерну складову.
And today's is about defining a roadmap to end sexual violence.
Сьогодні на цьому форумі ви обговорюватимете дорожню карту запобігання і протидії сексуальному насильству.
So let's try to make the road as short as possible so that women can live safely in our societies.
Давайте зробимо все для того, щоб ця дорога була максимально короткою, аби жінки могли виконувати свої ролі в суспільстві і насолоджуватися безпечним життям.
Thank you.
Дякую.
Дякуємо вам, пане П'єре.
Thank you, Pierre. And I physically pass the microphone to Jay Doty from USAID.
Join you for the 4th All-Ukrainian Forum of Women Lawyers. And congratulations.
Пані заступниця Генерального прокурора і менеджер з програми підтримки ОБСЄ в Україні пане Буасан, також пані Кіт, голова Юрфем, шановні учасники та учасниці від імені USAID, Американської агенції з міжнародного розвитку, мені дуже приємно долучитися до вашого 4-го всеукраїнського форуму жінок-юристок. Вітаю вас!
The initiative you are promoting in the frames of this forum, development of a legal roadmap for combating sexual violence, is critically important for survivors and witnesses, including those who suffered war-related sexual violence.
Ініціатива, яку ви просуваєте в рамках цього форуму, а саме розробка дорожньої юридичної карти для боротьби з сексуальним насильством, надзвичайно важливо для постраждалих та свідків, і в тому числі для тих, хто постраждав саме від сексуального насильства, пов'язаного із війною.
The U.S. government stands with Ukraine in supporting efforts to combat sexual violence and hold Russia accountable for war crimes, including sexual violence.
Уряд Сполучених Штатів стоїть пліч-опліч з Україною в боротьбі з цим сексуальним насильством і виступає за притягнення Росії до відповідальності за вчинені нею військові злочини, включаючи сексуальне насильство.
USAID, through its Justice for All activity, is supporting access to free legal aid for victims and witnesses, ensuring continuity of court operations during wartime, and building judge and defense counsel capacity to adjudicate war crimes in Ukrainian courts.
USAID через свою діяльність, програму, яка називається «Справедливість для всіх», підтримує доступ до безкоштовної, безоплатної правової допомоги для і потерпілих, і свідків. Минулий рік ми поставили обладнання на $500,000 для відновлення роботи 15 постраждалих від війни судів в Київській області.
USAID financed a network of local people-centered justice initiatives, providing legal services to more than 11,000 war-affected persons, And we also support the free legal aid system to address the legal needs of tens of thousands of citizens.
Також ми профінансували мережу місцевих ініціатив у сфері правосуддя, що орієнтовані на людей, які надають саме юридичні послуги, і надали вони їх більш як 11 тисячам осіб, що постраждали від війни. Також ми підтримали систему безоплатної правової допомоги для задоволення правових потреб десятків тисяч українських громадян.
We're also supporting non-governmental organizations that help survivors and witnesses of sexual violence, including UFEM and La Strada, Ukraine.
Ми також підтримуємо громадські організації, що допомагають жертвам та свідкам сексуального насильства, зокрема ЮРФЕМ та Ла Страда, Україна.
UFEM's recent study on the gender dimension of war, which provides a legal analysis of human rights violations and atrocity crimes for a survivor-centric approach, was realized, in fact, with USAID support.
Нещодавне дослідження ЮРФЕМ, яке називалося «Гендерний вимір війни», і що містить правовий аналіз порушень прав людини та жорстоких злочинів для підходу, орієнтованого саме на постраждалих, було реалізовано за підтримки Американської агенції з міжнародного розвитку USAID.
In La Strada, Ukraine, with USAID assistance, in cooperation with the Office of the Prosecutor General, is providing online support to victims and witnesses via chatbot.
Ла Страда, Україна за сприяння USAID та в співпраці з Офісом Генпрокурора надає онлайн-підтримку постраждалим та свідкам через чат-бот.
Overall, USAID remains committed to supporting Ukraine in combating sexual violence, including holding Russia accountable and assisting legal professionals to develop gender-sensitive skills to effectively handle cases of sexual violence.
Ну і в цілому USAID продовжує підтримувати Україну в боротьбі з сексуальним насильством, включаючи притягнення Росії до відповідальності та допомогу юристам у розвитку необхідних навичок, що враховують гендерні аспекти, аби ефективно розглядати справи про сексуальне насильство.
So I wish you all a very productive day of discussions, and thank you all for your attention, and thank you for your partnership.
Бажаю вам усім плідного дня, таких конструктивних дискусій і величезне вам спасибі за вашу участь в такій важливій темі. Дякую.
Дякую. Ну і
Thank you
підсумовуючи
very much.
вітальні слова
And summing
з
up
вітальним
the greeting
словом
words,
Христина
so
Кіт,
with the
очільниця
greeting word,
Юрфему. Христино, будь ласка.
Christina Kitt, head of UFEM. Thank you very much.
Працює там. От чудово. Вітаю, колеги. Вітаю на
Greetings,
нашому
dear
щорічному
colleagues,
форумі
and greeting you
Асоціації
at our
жінок-юристок
annual
України
forum
ЮРФЕМ. Насправді це
of
для нас така
Association
важлива
of Women
платформа,
Lawyers
яку
UFEM.
ми
It's a very important
започаткували,
platform for
тому
us
що
that
саме
we
в рамках
co-founded because in the
нашого щорічного
framework of
форуму
our
Асоціації
annual forum
жінок-юристок
of
ЮРФЕМ ми можемо
Women
обговорити
Lawyers
те, з
Association,
якими ми
we
викликами
can
зіштовхуємося в
discuss
сфері
the
гендерної
challenges that
рівності,
we are facing in
зрозуміти,
the
чи в
field of
правильному
gender
напрямку ми
equality,
рухаємося,
to
чи
understand
рухаємося ми
whether we
разом в
move in the
правильному
right
напрямку, тому що
direction and
надзвичайно
whether we
важлива це
move
синергія
together in the right
в нашій
direction,
роботі,
because the
роботі
synergy
усіх
in our
представників
work is
юридичної
very
професії,
important.
тому що не
And
можуть
a work
працювати
of all
лише
representatives of
адвокати,
legal
прокурори не
profession,
працювати,
it's
не
not
можуть
like
працювати лише
only
судді,
advocates will work and
слідчі, працівники поліції не працювати, не
prosecutors
можуть
won't. It's full-scale invasion presents us with the new challenges. This is sexual violence from the side of Russian soldiers, but at the same time, women, girls, men and boys who are living in different oblasts of Ukraine, cities and towns, they are facing cases of sexual violence not related to war. I think you felt this year and last year those informational reasons that we had in our society as a non-proper reaction of us as specialists to the cases of sexual violence that took place, and it's a huge challenge to us. And that is why today we are not just talking about the achievements in different fields, but it's incredibly important to discuss honestly and openly the problems that we are facing. And in addition to talking about problems, we have also to form the roadmap. So each one of us today has a very clear task to form recommendations that we will leave today with, recommendations for us, how we are going to work tomorrow, the next week, and the next year. And we will get all of those and we will send them to all the partners and participants of the forum, because we have to understand that we are processing all of that. And we have to understand that people in Ukraine who are living here, they don't feel themselves protected from sexual violence. And this is our responsibility as a people who have certain skills, knowledge, and experience in this field. I would like to thank our partners of the forum, and namely the Program of Support OECD and USAID program Justice for Everyone, who, so to say, pushed us to hold this forum this year. Every year since January, we start planning this forum of lawyers, and this year we had only 2 months, and we were in doubt whether we should do that or not, from safety issues and also the amount of work that we are doing, because we all understand how you're working right now. But I think it's a great opportunity that we are holding it right now, because we have to come together and talk whether we are on the same page, so to say, as for the challenges and problems that we have, and to find those common points. That is why I wish all of us fruitful communication, discussion, and we on purpose try to make our panels a bit longer, but it's not always possible. We're trying to stick to timing so that you can ask your questions, tell your opinion, and I will encourage you to ask questions to all the speakers who are going to be present here today, and those who are watching us on YouTube or who are online with us. Ask your questions, because this is a place for discussions and questions, and this is incredibly important as of today. So hello, thank you, and let us have a fruitful cooperation today. Thank you very much, Christina. Thank you very much to all of those who joined the greeting word, and I offer to begin the work from the discussion. I would like to ask Ms. Katerina and Christina to stay in your places, and all the rest, please come back to the room, and you will work from there. And now we will have a panel dedicated to war and sexual violence. Even though it's just a part of the forum, we understand that now it's the most resonating topic. And so are we beginning? So war and sexual violence, guarantees of non-repetition, moderator Christina Kitt, Ms. Katerina Levchenko. You already know her and you greeted her. She also takes her place. I invite Irina Didenko, head of the Specialized Department for Investigating Crimes of Conflict-Related Sexual Violence of the Office of the Prosecutor General in Crimes Related to Sexual Violence again. Ms. Irina, your position is very long. I don't know even how I would have presented you on TV. Then Alexander Baranov, Director on the Coordination Center for Legal Aid Provision. Then head of the Temporary Commission in Facts of Sexual Violence committed as a result of armed aggression of the Russian Federation. And Hershel Batyuk, the head of the International Migration Organization. So is everybody here? So during the discussion, please form your questions, and I will be running all along the room, and I will give you the microphone in order for you to be able to ask your questions. So Christina, we are ready to begin. Wonderful, thank you very much, Yana. Thank you very much, Yana. So the first panel discussion is dedicated to the topic of sexual violence related to conflict and guarantees of non-repetition. What can we do in this direction in order to never again repeat this? So if we are talking about sexual violence related to conflict, more than a year, we've been doing everything possible in order to react to sexual violence. So we are starting when working every day, and this is how it used to be. Because many of us are not lawyers or international lawyers. We never started like international humanitarian or international criminal law. That is why every day we were learning and we were cooperating together, and meanwhile we were formulating the policies, and we provided help to those who survived sexual violence related to conflict. So if we are talking about that, then it's important to mention that in May, between the government of Ukraine and special representative of the UN, Ms. Pramila Patton, we signed the framework program on prevention and combating sexual violence related to conflict. Vice Prime Minister created the interagency working group headed by Ms. Katerina Borisovna. And this interagency working group is making those plans and events that we have to implement in order to fulfill the program and ensure protection for those who suffered from sexual violence related to conflict. It's a colossal work that had been done with your coordination, Ms. Katerina, and how you united the NGOs and government in this part of reacting to sexual violence cases.
Багато чого ви, без сумніву, знаєте, і крім того, хтось з вас бував на заходах, на яких ми презентували цю роботу. Окрім того, тут є і члени тієї міжвідомчої робочої групи, про яку вже згадувала пані Катерина. Ну так, якщо подивитися на панель, то панель якраз представляє різні групи, різні підгрупи цієї міжвідомчої робочої групи. І це дуже добре, тому що це якраз показує, що об'єднуються не тільки органи виконавчої влади, ну що може робити Кабінет міністрів, але співпрацює разом з Офісом Генерального прокурора, і ми дуже цінуємо цю роботу, що є робота з суддівською гілкою влади, це також є дуже важливо, з міжнародними організаціями, Міжнародна організація міграції разом з Фондом народонаселення, ООН жінки,
UNFPA and Council of Europe. And I don't know, by the way, whether we have representatives of OECD and OSCE. We also have to change that, and a huge number of NGOs. I would like to say that this working group is open, that is those who want to coordinate their activities, they are joining us, and only in such a manner we are doing our work. So my speech today is dedicated to answer the question, coordination, how and what for? How do we coordinate and what for actually? Why do we do that? The ground for our policies was the framework cooperation program mentioned by Christina. You can find the program in the internet. It is there in Ukrainian and English on the website of the Cabinet of Ministers of Ukraine. But it is worth to know some things about that. It was prepared in a really fast manner. It was created in days, not even weeks. We involved different state structures from Ukrainian side, Office for Pramila Patton. It was a dialogue. It was a dialogue in wording, because it was important for us also that the language that we use in regards to the events of war of Russia against Ukraine would be maximally represented in this document. We all know that, unfortunately, UN, being many UN agencies, so to say, being under Russian impact, they are using language that today we will call it hybrid language, which is bringing hybrid threats in it. So this document was processed in a really fast manner. It was signed, and it has 16 main tasks. We, together with the Office of Pramila Patton, we put them together into 5 main directions, and I will mention about the direction a bit later, talking about the subgroups of the interagency working group. But as a base of our state policy, in the base is a legal base, which is actually this framework program on cooperation. This is very important, and you as lawyers understand that any actions have to rely on the legal background. And in addition to conventions, resolutions of the Security Council of the UN, we have very clear mechanisms. And this document is answering to a lot of challenges in terms of prevention and combating sexual violence, that those cases that we observed last year and we started answering to in our activity all organizations, all structures, but nevertheless, they still remain. Because when we are talking about some things that had been done, and when we are talking about the achievements that we've got, we are turning the page, and we understand that each achievement is creating a new challenge or is the answer to the challenge. Therefore, to say that we resolved this or other problem, I can't say that as of now. Can I ask you to give me my purse, if possible? Carefully, not to open it, because I have some additional information materials here. And the challenges that are there, they are also in the field of scientific part, like determining national legislation, that is also low level of informing about the facts. This is unethical behavior. I think that this reduced already, but it still exists. And in society, it's like we know how to treat each other. But nevertheless, the facts of unethical behavior, they always will be there. So we have to pay attention to that. And the question is that all those things are in the field of attention of state structures. And I know you are going to talk about this because a very important role of a legal system, of prosecutors, of police training. It's something that both of us are working on, and that's information for different target groups, and such information campaigns, fortunately, have already started. As it was already mentioned in the framework program itself, its provisions had to be reflected in the updated National Plan of Actions in order to perform resolution of the Security Council of the UN. And this created, again, new legal reasons for us on the national level in order to continue this work. But, however, performers of this framework program are not only Ukrainian side, all the subjects of state policy, but also those who are implementing this framework program are UN agencies, because it was signed between the UN and Ukraine. And National Plan of Actions as a document which would coordinate work on performing the framework program, clearly it was not enough to have just this document. Therefore, we developed implementation plan on implementation of a framework program on cooperation. In the updated plan, a lot of tasks is contained regarding sexual violence related to conflict. We also have our plan on the website, the Cabinets of Ministers and website of Verkhovna Rada. It was adopted on 16th of December 2022. And we also worked quickly in order for this document to be updated. And that is a good also coordination tool for work of different structures. When we are talking about the mechanisms of coordination, then among the mechanisms of coordination, for sure, those are parallel processes, what I'm looking for and what I'm saying. Committee on interaction of executive bodies and ensuring equal rights and opportunities of women and men that are headed by Vice Prime Minister on European and Euro-Atlantic integration, Ms. Olga Stefanishina. That is the interagency group that Ms. Christina mentioned. Sectoral working group, gender equality of the third level of coordination of international technical aid, which gives opportunity of active communication with international organizations and donors. And those are 5 thematic subgroups of the interagency working group, which I already mentioned, and that correspond to main directions of framework agreement.
Recording in
Prevention
progress.
of human trafficking, complex holistic help to the victims, justice and responsibility, strengthening capabilities of the sector of defense to work in this field, reparations and compensations, And now we have number 6, group number 6, which will come together soon and is dedicated to issues of unification of trainings in the basic part, which is unified for everyone. Because we see that different organizations are using different approaches. That is the challenge that is shown as a challenge. This is a challenge that we see in our practice. So, as I've already mentioned, if you want additional information, it is in free access.
What I wanted to show you, implementation plan, just to distribute. So we use new technologies to save paper, make it paperless. Okay, so the information on implementation plan execution for the framework program of cooperation. All interagency working group members were given. So this, I do hope you'll open it. Actually, it will be functional. Okay, the QR codes. All right, and everyone received the QR codes. It's not confidential. All right. So we actually use it like a tool to coordinate as well. Because when you know what others people are doing, it works. Yeah, super great. So yeah. Oversight is an internal function of the prosecution. Yes, you control everything, you oversee everything. Great. And it will help us to understand what is already done, where we have to move further. Okay, so if we talk about regional level, we have authorized coordinators, advisory bodies on ensuring equal rights and opportunities for men and women. We have these in all regions, by the way. And within the last year, we added also prosecutors there in defense security sector. Why? To meet the challenges that we have and to provide support and assistance, the initiative of Ms. Stephanie Shina to establish survivor relief centers together with the UNFPA. We have Aurora platform, psychotherapeutic support as well, and also the platform to help survivors, where we collect data in all organizations and services, providing that kind of assistance. Again, it's about helping us to coordinate. Filling with content, filling all this activity with content, creating the content, establishing measures and actions which would comply with current challenges. I think this is a very important task for all of us, including the participants of the forum. Thank you so much for attention. Thank you. Thank you. Thank you, Ms. Katarina. It's really a very important work. And as you mentioned, the platforms and the platforms for war crime survivors, including sexual violence, support centers, these will be functional only when we effectively are engaged in this activity as representatives of legal community and disseminate this information, informing, creating the system of trust to us, to those people who are ready to respond to CRSV cases. And this challenge is for law enforcement as well. It's the same, it's even bigger for them compared to lawyers, they have to contribute more. I would love to ask Ms. Irina Didenko. Ms. Irina, how did the approach change, the prosecutor's approach, to respond to CRSV cases? Because we say that we have so many of them. Not so many of those identified, but at the same time, Prosecutor General's office established this special CRSV unit, and they demonstrate in such a way that you are ready to change your approaches and policies. I know that within more than a year, you've been designing the strategic approach, survivor-centered, to handle CRSV cases. Please share with us this approach, at which stage, how to implement this. The most important for us, for specialists, and we also have lawyers and judges here, the prosecutors, police as well. What challenges do you face as prosecution experts? Because you're going there to the occupied territories, to the occupied settlements, and how can we enhance, all of you enhance your efforts, please? Thank you, Ms. Christina. First of all, I'd like to express gratitude for invitation to this event. It's organized in such a wonderful manner. Everything Christina is doing. Thank you so much for it. It's true. Yesterday, we had conversation with colleagues, and I love this statement, and it is true. It's so nice to feel myself a part of this world when the hell is somewhere there and you can move, you can evolve in legitimately, you can actually improve your practices. Thank you for this chance to armed forces, of course. It's so cool that now we can talk within this community about these important issues. So when it comes to 2023, this is a super hard year for all of us. I think everyone has a story to tell. I just want to go back a little bit. So colleagues, for so many years, we've been cooperating, yeah? And previously, we focused on domestic violence and GBV. And coming back, like, I'm trying to remember the period, what comes to my mind? That we were moving forward, but gradually, step by step, like an evolving democracy, moving with small steps, baby steps, yeah? So we managed to do something, somewhere failed, but after full-scale invasion, in my opinion, many things came to the surface. Everything that could come to the surface, the world became black and white for us. And all these problems we had to tackle, they are more obvious now. When it comes to approach, survivor-based approach, even my colleagues, investigators, I ask them, don't you want to protect the person who suffered? Like, don't you have the wish? In the system, for the system, it was also always convenient to move in a paradigm to prove the guilt, and that's it. Yeah, like full stop. Nobody cared about anything. Yeah, just showing the indicator, giving the KPIs. Yes, we still have. But now we just want a huge wish to protect, to take care, to support as much as you can the survivor. And after all this became so obvious, unprecedented joint effort at all levels. Previously we moved in our own bubble, in our paradigm. Right now we can see that supporting survivors and witnesses of war crimes, the whole country is uniting around it. This experience of merging the efforts, the best practices, we will bring it to other categories of crimes for for peaceful life crimes. What do we see with the figures? The figures that we identify? 208 facts of sexual violence. Not much, of course, not because there are no such crimes committed, but because we underperform. Because not always people trust us, and sometimes it's justified, purely justified. People are not aware. We still have the stigma. We had to start fighting it previously, and now 3 times harder and faster we have to do it. So when it comes to our strategic approaches, thanks for this question. Half of Murat Code, our prosecutor general, he actually approved this half of the code in our strategy. It's there in the prosecution strategy development. This step shows that no time for waiting or hesitating and designing these strategic mechanisms. We have to start acting now. And we started doing that. And in parallel line, we created a strategic plan for us. I do hope that soon we will approve it as well, thanks to our international partners who helped us to design it. We'll have a QR code as well. Yeah, to save trees. I support that. Thank you for the good idea. Okay. So we're moving, but so many challenges we have in front of us. Katarina is very correct. So with every step, we understand that we have to revise the strategy. It's not even approved, but we have to amend it. Every time, new challenges. And I just want to share the problems I think we have to start raising now. What Christina said. For our discussion to be practical, and I will share the opinions and you can later add something or object if you want to. Like, for example, first of all, my unit wants to take all criminal proceedings and revise them since 2014. Analyze these. Evaluate the pretrial investigations, what approaches were used, and have like a report to tell the people what happened since 2014. We understand that with occupation in our country, we won't have the real picture, but the signals, those people who managed to leave, we have to raise this to the surface and discuss it and show it. Then a big lump of work, we have prisoners and captives. Talking to these people, we realized that sexual violence was almost in every case. People are not ready to talk about it, and people are not ready to reveal they don't understand what sexual violence is fully. A lot of work, approximately 3,000 of exchange prisoners, and we just have to raise that and help them as well. All right, other issues, so-called the civilian captives, those who will held captive civilians, a separate issue. We just have to merge efforts, especially with doctors, because if military prisoners at least get some support from the state program, the captives are like beyond that a little bit. They don't know where to go. They have serious problems with health. With the last captive I talked to, he had serious problems because he had sexual violence. His genitals were electrocuted, and he says, Irina, I have a problem. I don't know where to go. We have to look for ways to provide help to these people somehow as well. Cooperation with doctors, by the way, with IOM, we start doing this with doctors. Maybe they're not the first responders. They do not identify the problem, but they have to be the ones who detect it, because first the doctor has to examine a person. The person must feel safe. And only then we can start talking about pretrial investigation and liability of perpetrators. Murat Code, Katerina was right with that. A lot to do for all of our colleagues to start using it in their job, because we can't physically take, our unit in the office cannot take all the cases all around the country. People work locally, they're investigators, community officers, and so on. All these people have to know how to talk, how to communicate, not showing sympathy. The first thing they say, oh, we just need to give a hug. No, these people survived a horrible thing. They just have to be supported and helped with actual things. Then something we left beyond, but it's important. Everyone who works with witnesses and survivors of war crimes, they may be effective only when they have the resources. Yeah, when they're resourceful. Taking care of yourself, self-care, working with people, with information. And when you know how this is done, you can help other people, because you can do harm. You can incorporate your emotions there. It's important. By the way, we haven't had no trainings. We'll be happy to get that as well. Legal aspects then. We had another problem. For the person to initiate a criminal process, first there must be an application or a special document filed, and then an interview, and it's re-traumatizing. Yeah, so a lot of bureaucracy. Now we have a special type of proceeding where we can start interviewing people without these applications. It's like a manual mode. It's not the thing, but yeah, we found this anyway. We have to solve this problem legally and team responsibility, because we understand who is executing, but commanders know about it. They tolerate, they give orders, and national legislation does not give us a chance to hold them liable. A lot of problems are there, but nothing will stop the idea that is due. So if we merge the efforts, we will definitely try to, we'll tackle it and we'll find the best solution for it. Thank you. Of course. Sure. Thanks, Irina. Yeah. Please, just briefly, because we have to, yeah, briefly I will. I have a very practical proposal, highly practical proposal for Irina. She's the representative of PGO. Okay, so we can have this working meeting with those organizations providing support, because I do see that organizations are doing their own thing, you're doing your own thing. We need to have a bridge between these islands, okay? Let us plan that. We'll be really happy if Eurofam helps us to build a bridge. Okay. Ms. Katrina, thank you for the proposal. You can see very clear recommendations, the steps we're generating during the forum. Thank you. Ms. Irina mentioned the legal aspects and some obstacles that we face when we respond to sexual violence, to CRSV cases. And it's related to our legislation, the applicable one, CPC. It's not survivor focused at all, especially for CRSV cases. And if you talk about legislative branch of power, the active voice of sexual violence problems and gender equality, Miss Marina Bardina, she's an MP. And upon the initiative of Miss Irina, a temporary investigation commission was established to investigate facts of sexual violence committed as a result of the armed aggression of Russian Federation against Ukraine. I have a question. First of all, what are the tasks of this commission for us as lawyers to understand how do you work, and why was there a need to establish it? If this commission is effectively working, do MPs understand what the challenges are, like law enforcement, what challenges they have, like judiciary, when it comes to legislation, and which legislative initiatives you have primary ones, like on your table to advocate these and implement, all right? Thank you, Christina. Good morning to everyone. I think that if I start answering questions, you as lawyers may even argue with me a little bit, because commission, according to legislation, it has certain functions, but we go beyond the functional, and maybe not because we want to, but because these are the conditions and this is the reality we live in. Yeah. So yes, based on the legislative tools of the commission, we had so many meetings with law enforcement, by the way, psychologists working in the fields with CRSV survivors, NGOs, CSOs, international colleagues. We tried to merge all these areas. Quite often people at our commission meetings were meeting each other and just getting some information about investigations or the job that was done in CRSV Meta. And we were we were like summarizing and compiling that. What's more important, I think, in our commission's work, in MP's work, designing legislation which will improve the applicable one, protecting those who suffered from CRSV in legislative area, doing it better than we can now. And what was my own pain, what I took care of, supporting people who already are survivors of CRSV. And the commission gave a chance of this partnership for us, like cooperation, coordination between various branches of power, law enforcement system, and us. And I'm so glad that we have Irina and Christina on the board and everyone who were in this working group. And they offered amendments to applicable legislation. This draft law is registered today. And the co-authors, I guess, if not all the factions and groups of parliament, but almost all.
Therefore, further on the advocacy, like internal, I think all the deputies understand the importance and they will support. By the way, the legislation concerning domestic violence, for example, it always has a majority and it does not cause any discussions in the parliament. And here we offer the amendments in terms of protection of people who suffered from violence and also their personal data processing, and also for the national police to be able to be involved not only to certain investigations. I think it would be correct taking into account the police. It happened. So now I am not saying that the security service of Ukraine is working in the bad manner, but we are talking about domestic violence, and in terms of practice, because they've been doing more that, so they know how to communicate with the survivors of domestic violence. Of course, when we are talking about sexual violence related to conflict, is different, but in both cases, it's violence. So I think that national police can strengthen and help the state to investigate these kind of crimes. And second legislation that I mentioned, we started working on since May last year, because it was obvious that such a legislation, proper legislation, is not present in Ukraine, and we have to work on that. We studied experience of the countries who had a conflict, that was Croatia, Kosovo, Bosnia, and we started looking for a model which can be adapted for Ukraine, and we process such legislation. It is not registered yet. I would like to thank your family, and Christina, to you personally, that so much time you spend in order to for us to process that better and better, and to improve that on and on. It's a new experience, even though the war is taking place in Ukraine for almost 10 years already, but still, we understand really that we don't really want to go the same way as Croatia, because they provided aid to the survivors of sexual-based to sexual violence related to conflict only 15 years after. So we want to have it differently. We want people not to wait for the sentence of court, which not always can be fast. So I think you know that much better than I do. So we offer in the draft law very clear things. First of all, to create a committee which will not take the functions of investigation, but altogether they will have the power in order for the person who addresses the committee to state the fact whether the person survived or not this kind of violence. So those can be some partial reparations or compensation, because we all know that Russia has to pay for the crime committed by it, but people need help right now. And this is psychological help, and this is free of charge medical help to the survivors of sexual violence related to conflict. I would not add some more offers like free of charge stunning or some other things, because it seems to me that right now it's a moment of some clear and understandable things, that they can come, they can get something in there, they understand that the state performed its function and provided this kind of support now, and not one day that they will expect that, stay in queue, some bureaucracy and so on and so forth. So this is how the work is going on. I really want us to register this draft law and to offer as a state the model of help, legal model to the survivors. So we are cooperating with the government, we're cooperating with the public sector in order to find the right answer, because it seems to me that not a single person can say how it works. There is no one person who can tell us how to do that, but we can invent, because we are creative, we are Ukrainians, you know, we can invent something new, but something that will work for us in Ukraine. And unfortunately, further on, we are going to be the state which can share such kind of experience. And hopefully not a single country will need such experience, but we've been working a lot with that. We can talk about that, and we understand at least how to do that more or less correctly. Thank you very much, Marina. From our side, indeed, we would like to thank you for listening to the voice of legal community, because you're sending us the ready-made draft laws in order to read and to assess. And this is very valuable. And this is what we've been aiming at when we created our association, so that lawyers' voices that work in practice with defending the survivors from sexual violence we are heard because we know what will work, what won't work, and how we can improve that. And talking about such legal aid to survivors of sexual violence related to conflict, it is incredibly valuable because we can create tools, but people without legal support, they cannot use the rights and possibilities because they won't know the algorithm. They don't have to know the algorithm. It's our task to explain this, to support them, and to help. And incredibly important it is that it seems to me that in April last year, there were some amendments to the law of Ukraine on free of charge legal aid. And actually those survivors, they are members of free of charge aid, also secondary aid, which is incredibly important. And Mr. Alexander, a year has passed since then, and how did you transform maybe your work? Maybe you somehow like shifted accents, maybe there are lawyers who are supporting the survivors. How do you communicate the survivors of military crimes, including sexual violence related to conflict, and what are the things? So what is necessary in order for this work to be more efficient? Thank you very much. We have presentation, so if possible. So it's already almost like it was April, but it's during the 2 weeks. In 2 weeks, we made amendments. It was really fast. And one more subject of the survivors of the crimes against sexual independence or like torturing and abuse. So we covered sexual violence related to conflict in more broad sense, but at the same time, we also covered the right to free of charge legal aid. Yes, we heard that we have 280 cases, unfortunately, and since May 2022, not a single client did not come for free of charge legal aid to our system. Here we can have different factors why it is so, but the most important thing, what we are talking about all the time, and that is being discussed on different events, the problem of sexual violence related to conflict in this society is not on the really high level. And we started a big information campaign, and we conducted a sociological study, and more than 1,000 people participated from all the regions of Ukraine. And as you can see in numbers, 69% of people consider that the problems, this kind of problem, is very acute, and at the same time, 60% think that the problem is not discussed enough as of today. So yeah, 40% are saying that it's not like that. But we can say that more than half of the society, those who provided answers, they think that this problem is not discussed enough, and we have to work with that. We have to talk about that all the time, not a single time, not only on forums, all the time and everywhere. If you can see, like according to the data of this study, we have 2% who said that they suffered from sexual violence related to conflict, and if you just take that to the whole territory of Ukraine, we get the crazy amount of people who suffered. Today, people are consuming mostly information from social networks, from national TV. And that was actually the answer that we got during the study, that most people are getting information from social networks, from national television, and we continue a very powerful information campaign. What are we fighting with, and what are we talking about? Indeed, there is such a stigma that people consider that they did something wrong, that they could not protect themselves, or they provoked sexual violence. And of course, all the time we are talking about the fact that there is stigma from the side of society towards the survivors, because we are seeing that as provoked. And action. We have few campaigns and we are spreading a series of information. What is sexual violence? What kind of sexual violence is there related to conflict? I mean, because most people think that it's only about the rape, but we are saying that it's not only rape, it's much more. And how can we provide legal aid when we have sexual violence related to conflict? A lot of attention is paid to the fact that it is long-term help. And if people are ready to come for help to the legal system, and not only to the legal system, but when they are ready, when they will feel safe, then they can come, because there's no like limitation period. So now we had a lot of information campaigns on prevention of violence on national TV. Then we cover more than 1 million people in the internet, and we show it as an ad. We had more than 700,000 shows. You can see the video, you can see the QR code, you can just take a photo of the QR code and you can share that in your own social networks. So I think that next week we will start showing this ad in Intercity. So every 20 minutes it will be shown in the trains. But again, what we are talking about all the time, we are coming back to that. People have to know that such problem exists. People have to know that they can come and ask for help when they will be ready to address this issue. They don't have to do it right now and right here and today. And I hope that while people will be considering whether they are ready to ask for help or not, the state institutions will make everything, will put much effort in order to develop mechanisms that will help, indeed, help people to come back to normal life. Thank you. Thank you very much, Alexander. Thank you, Alexander. Actually, you know that in our organization, we also have a line of help, online support for those who suffer from sexual violence. And we face the fact that people, sometimes even knowing that they can get this kind of legal aid, they don't know why do they need it. Like if there is someone who suffered prosecution, is making investigation actions, how the lawyer can help me in this situation. And people don't understand that there are some moments related to reparations and again, the status of the survivor and so on. Those are the notions that are not covered by the legal system, but it has to be done by lawyers and advocates. Because advocacy with the survivors in such language, what can we offer them? Because the issue of legal aid is really broad and not all people understand what is so valuable in this. And I cannot stop myself but ask you, a few years we were already raising the issue of not only sexual violence related to war, but in general, sexual violence crimes and protection of the victims. We were talking about amendments to laws that it is mandatory to assign a lawyer, not only to the person who is suspected, but also we have to assign them to victims, to the survivors. I'm sure that you heard such discussions, and does the system of the system has their own position, and do you think it's correct or not when we are protecting the survivors' rights? Now we are working in the direction, so to say, of forced legal aid to children, because all children they have right for free of charge legal aid. So if the child is a survivor of like sexual crimes in particular, very often we see that perpetrators have defenders, one or a few, and the child does not have even a single lawyer who will protect their rights in court. So yes, we are working in this direction, and in the nearest time, we're going to submit our initiatives. Wonderful, wonderful. Thank you. I think we can see how this algorithm works and then to expand that not only to children, but also to the victims of sexual crimes, because those are people who need support at the very beginning when they address and they communicate with the legal bodies. But if we are talking about legal aid, unfortunately, we also face the fact that, yes, we have air alert. I think that yes, let us, yeah, works, no? So we have the rockets. So let us quickly go to the floor in -2. If you need elevator, it's right here in the wall. The doors in order to go down the stairs are to the left if we look from my point, and we will continue there. We won't just sit, we will work. So let us do it while so quickly we go to the shelter. That is, nobody is agreeing about that in victims. So here it is worth making amendments to legislation in order to reduce this sexual violence. Because if we are talking about reparation, then one of parts of it is a request for justice for that person. My question to you is whether we are working in this direction to make certain amendments, because until we have such legal opportunity to substitute certain parts of criminal responsibility. So internally, there will be some contradictions, but they have to come with it. Thank you. It's my question. So let us, in order of the questions asked, first Mr. Alexander, then Ms. Irina. Thank you very much. As for the debts to lawyers, we are talking about that all the time, and directors of regional centers and local centers have to be here. This is not related to the system of free of charge legal aid. This is related to the mechanism, but financing. The system of free of charge legal aid never receives at the beginning of year the whole budget. This budget is distributed for months, and depending on how it is distributed by the Ministry of Finance, we can pay remuneration to the lawyers. The first year when we could achieve distribution of assignations for a year, it was 2022, but the war started. And today, almost 75% of all the budget that has to be received, like first half. Unfortunately, the connection is unstable. Some people are having one training like dozens of times, and some don't receive the necessary knowledge. So we have such an idea as of now to make it in the form of a table. What kind of trainings are offered? Who are speakers? Who wants to undergo that? And of course, we are going to involve like 100 of displaced people. So there is another department. I will mention my own opinion. We had a meeting.
So, and why this is important, actually.
participants and discussion with Françoise. Please let me know if you hear me. Unfortunately,
цікаво спілкуватися одне з одним, одна з одною, тому це теж, напевно, важливе спілкування. Дякую Христині Кіт за те, що, власне, показала оцю картинку реальності та реального сприйняття. Мені здається, реального сприйняття людьми, які потерпіли, ми не всі зізнаються, які стикаються з цим як свідки чи очевидці, і які просто мають знати, що ми недостатньо, напевно, добре і ефективно реагуємо на сексуальне насильство в приватному житті, в публічних просторах, недостатньо почуваємося в безпеці як громадяни і громадянки, і це дуже важливий такий зріз стосовно довіри до правосуддя, наскільки можна досягнути справедливості у цих справах. Так? І мені здається, що це якраз оця картинка, яку ми бачили, і ці цифри, вони нам задають, так би мовити, тональність нашої розмови. Я би почала напевно, з того, наскільки втілюється зараз, з вашої точки зору, от, власне, потерпілий підхід. Цей термін і цей підхід вже згадали ми тут на початку, і оскільки наші учасниці, які поруч зі мною, можуть, мені здається, з різних поглядів на це говорити і з боку адвокатури, і з боку прокуратури, то це було б, напевно, Пані Ірино, давайте почнемо. От як сидимо, так почнемо. Ольга, пані Ольго, перепрошую. Так. Так?
Доброго дня, шановні колеги, колежанки. Я б сказала з впевненістю, пані Ірина Діденко вже пішла, але б я думаю, що вона підтвердила мої слова, що з перших днів такої координації спільної дії слідчих і прокурорів щодо запобігання та протидії сексуального насильства в умовах війни, оці орієнтовані підходи були впроваджені в першу чергу. Вони були впроваджені в навчальні програми, в методичні рекомендації, в тренінги, в будь-які модулі, які відповідали, які мали собі за мету сферу навчити, швидко навчити наших правоохоронні органи реагувати на такі події. Нещодавно ми мали особисту зустріч з Надією Мурат. Це колосальна історична подія була. Я особисто брала участь і дійсно мені дуже було приємно з нею познайомитися. Я вивчила її історію, її життя, яка спалахнула дійсно. І навіть чоловіки, які читали, ми ж, здаємося, кажуть, що чоловіки більш такі стримані, теж були здивовані ці пережитого, вона змогла допомогти ще 1000 людям. І ми говорили всі в один голос, що дякуємо вам за ці кодекс поведінки, дякуємо вам за ті принципи, які ви врахували в цей кодекс поведінки, які ми зараз їх впроваджуємо вже існуючими в нашу систему. І дійсно ці принципи є основою будь-яких документів, які направлені на підвищення обізнаності наших поліцейських. Тому що ті принципи – це повага до постраждалої особи, це розуміння її, це ні в коєму разі не звинувачення, це правильна комунікація. Чому? Тому що поліцейські – це перші, які після деокупації, після військових Збройних сил України контактують з населенням, які були в окупації. І оці принципи, вони повинні дотримуватися, і це реально зараз вже протягом цього останнього часу вони показують свої результати. Ми маємо, якщо всі знають статистику на початку, практично нульові статистичні дані, нульові звернення. Вони зараз збільшуються. І збільшуються тому, що люди нас чують, ми це говоримо, і навіть зараз, якщо воно транслюється, та людина...
Експертка в сфері кримінальної юстиції і членкиня громадської організації ЮРФЕМ. До речі, кандидатка юридичних наук так само.
Дякую, Тетяно, дякую, колеги, за запрошення. Я маю сказати щиро, що дійсно вивчаючи і практику, і ті нормативні документи, які останнім часом приймаються, і те, як працює Офіс Генерального прокурора, і Національна поліція, мені приємно, що робота йде. І я в сфері кримінальної юстиції понад 20 років і весь час працюю з загальним криміналом, як кажуть. Дуже тішить, що щось змінюється, але дуже би хотіла, щоб це було не тільки те, що ми бачимо гарну картинку. А насправді хотіла сказати, що робота з потерпілими по СНПК – це попередня панель, я теж скажу, що працюю з такими справами, і дуже високий рівень і органів досудового розслідування, починає Служба безпеки України, підслідність якої ці справи, і Національна поліція, яка перехоплює естафету, продовжуючи розслідувати справи. І прокурори в цих справах дуже потужні, дуже кваліфіковані, і вони чують в тому числі адвокатів, які представляють потерпілих, вони вміють працювати з потерпілими, здебільшого це дуже добре. Щодо загальних кримінальних проваджень, щодо роботи з потерпілими від сексуального насильства, на жаль, в мене не настільки радужні і приємні враження, тому що те, що я бачу в своїй роботі, потерпілі жінки, як правило, які звертаються до органів Національної поліції після зґвалтування, після сексуального насильства, вони зазнають повторну травматизацію під час подання заяви, особливо коли немає в них адвокаток, тому що, ну, от направду, потерпіла іноді водиться 3-4 кабінетами, а давайте ви розкажете ще раз, і не факт, що ми зареєструємо так кримінальне провадження. І тут я би хотіла сказати в контексті не просто поговорити, а тої ідеї, що ми тут зібралися, аби напрацювати якісь спільні підходи. Прокурори Офісу Генерального прокурора, і була заступниця і Генерального прокурора, і начальниця департаменту пані Ірина Діденко, і пані Ірина, знаю її дуже як фахового прокурора, теж підтвердять, вони дійсно працюють, вони напрацьовують і методичні рекомендації, і в своїх підрозділах допомагають прокурорам рости в цих справах. А коли ми працюємо на місцевому рівні, на жаль, прокурори місцевих прокуратур, вони просто не знають, як з цим працювати. І вони самі кажуть, у нас є брак навчання, брак якоїсь комунікації, брак розуміння, яка йде практика. Тому одна з моїх пропозицій була би зробити якісь, можливо, спільні, більш контактні заходи, де були б і прокурори Офісу Генерального прокурора, і прокурори прокуратури нижчого рівня, для того, щоб дещо врівноважити оці знання, розуміння і підходи. Тому що на місцях, насправді, прокурори дуже хочуть. У мене дуже позитивний досвід по одній з моїх справ, де я працюю з потерпілою, представляю як адвокатка, коли саме прокурор зорієнтував слідчу, що є така організація, як ЮРФЕМ, і слідча зорієнтувала потерпілу, і таким чином ми знайшлись. І дійсно є співпраця на досудовому розслідуванні і бажання допомогти потерпілій особі. Тому я закликаю нас всіх працювати разом. Ми працюємо всі на одну велику ідею і справу – захист прав потерпілих від сексуальних злочинів. Це не тільки жінки, це діти, це чоловіки. Давайте об'єднуватись.
Доброго дня, мене звуть Ірина. Я сьогодні представляю департамент Офісу Генерального прокурора, департамент, в якому я працюю, спеціалізується у нагляді за центральним апаратом органів Національної поліції та за територіальними підрозділами органів Національної поліції. Сьогодні я прийшла зі статистичними даними, я їх можу озвучити. Єдине, що хочу одразу помітити, що всі ті цифри, про які я буду говорити, вони не стосуються фактів СНПК. Лише і тільки сексуальне насильство, те, що не пов'язано з конфліктом. Тобто це кваліфікація 152, 154 Кримінального кодексу України. І можу сказати, що на сьогоднішній день у нас впроваджені 533 кримінальних правопорушення. Органами Національної поліції розслідуються. В цих кримінальних провадженнях надано статус потерпілої особи 496 потерпілих, з них 317 жінок і 129 неповнолітніх. У 80 кримінальних правопорушеннях, які зараз розслідуються органами поліції, у 80 кримінальних правопорушеннях повідомлено про підозру. В 2022 році таких кримінальних правопорушень нами було скеровано до суду обвинувальних актів 316. В 2023 році, вже станом на 1 червня, 143 обвинувальних акти. Тепер те, що стосується розгляду судами. В 2022 році було розглянуто 164 обвинувальні акти, в цьому році розглянуто 53 обвинувальні акти. Основна проблема, яка дійсно існує на місцях, це відсутність належної комунікації. Про що я говорю? Якщо ми звертаємо увагу в першу чергу надання допомоги потерпілої на стадії досудового розслідування, то в подальшому, коли матеріали передаються до суду, ми бачимо, що потерпіла так само продовжує потребувати підтримки тоді, коли справа перебуває на розгляді безпосередньо у суді. І певним чином є певна проблема, тому що спливає час, І знаєте, як говорять, нічого так не знищує справу, як час. Да? Ось так само, якщо, наприклад, обвинувальний акт перебуває на розгляді у суді там 2 або 3 роки, просто в якийсь момент потерпіла перестає відвідувати судові засідання і відмовляється йти на будь-яку комунікацію з прокурором. Є так само в нас проблема у проведенні слідчих дій. В чому вона заключається? Ми, намагаючись зорієнтувати слідчого і прокурора предметно співпрацювати з потерпілою, обмежити будь-яке спілкування з нею сторонніх осіб. Так само ми орієнтуємо прокурора про те, що деякі слідчі дії він може провести особисто з метою недопущення повторної травматизації. Але разом з тим ми маємо і розуміти, що на територіях, особливо там на деокупованих територіях, на прифронтових територіях, слідчі і прокурори задіяні в значній кількості розслідування інших кримінальних правопорушень. І якщо, наприклад, слідчий може 2 доби проводити огляд території, да, яка зазнала бомбардувань, так, або є у нас пошкоджені там цивільні об'єкти, то в такому випадку ми можемо не провести слідчу дію, ми можемо її перенести, і це так само впливає на стан потерпілих. Щодо співпраці потерпілих з адвокатами, так, дійсно є така проблема, скажімо так, тому що потерпілі дійсно не завжди користуються правовою допомогою. І навіть в тих випадках, коли їм відмовляють в реєстрації їх заяви про початок досудового розслідування, лише, я думаю, що це мізерний відсоток звертається до вищестоящих органів прокуратури, зокрема до Офісу Генерального прокурора з відповідними заявами про те, що їм відмовлено. До того часу, поки вони про це нам не скажуть, зрозуміло, ми про це не знаємо. Тобто ми не можемо на це належним чином відреагувати. Тому ось та кваліфікована правова допомога, вона є необхідною в цій категорії злочинів. Тим паче, що варто виключати, що, розумієте, саме сексуальне насильство, де у нас встановлені особи, так, підозрювані, це наші громадяни і наші потерпілі їх бачать, вони з ними бачаться в суді, тобто це не заочне переслідування. І дуже часто трапляються такі випадки, коли потерпіла на якомусь етапі в судовому засіданні починає змінювати покази, починає говорити зовсім інше про ті обставини, які були. Тобто це говорить про що? Це говорить про те, що на неї сторона впливає, так? Тобто наш обвинувачений, якого ми обвинувачуємо, обвинувачена, або вони впливають на нашу потерпілу особу. Для того, щоб стан досудового розслідування покращився, і для того, щоб ми дійшли до належного результату нашої роботи, а це вироки і вироки з справедливою мірою покарання, да, будемо так говорити, на моє особисте переконання, було б дуже доречно проводити не просто навчання окремо слідчих і прокурорів, да, а от, як зазначила пані Людмила, дуже корисно буде, коли це буде в комплексі. Я багато разів приймала участь у заходах, онлайн-заходах, так, де присутній, наприклад, слідчий, прокурор, тоді слідчий прокурор говорить про те, що немає належного притягнення до відповідальності, тому що суд довго не розглядає матеріали, так, суд затягує провадження. Коли ти приймаєш участь у заході, де присутній представник суда, тоді говорять про те, що так, прокурор не з'являється в судові засідання, або затягує судовий розгляд, або не забезпечує там явку свідків сторони обвинувачення. Коли ми будемо усі збиратися разом, я думаю, саме в той момент буде встановлена істина, всі оті проблеми, які не дозволяють нам довести навіть 5000 кримінальних проваджень, які у нас є сьогодні, до суду, і добитися вироків в цих провадженнях. І я більш ніж переконана, що їх більше, ніж 5000. Тобто є, а для того, щоб їх стало більше, для того, щоб ми розуміли, яка насправді є реальна картина, нам необхідно просто продемонструвати суспільству про те, що кривдник дійсно несе покарання. Дякую вам дуже.
Дякую вам, пані Ірино. І вже бачимо, навіть от так, ми лише розпочали панель, але запит на навчання та або запит на якісь спільні комплексні навчання вже пролунав фактично від кожної з наших учасниць. І це те, що можна додати таким маленьким пунктом до рекомендацій. Незважаючи на те, що ми з вами перемістилися в укриття, у нас зараз, я сподіваюся, буде плідна спроба все ж таки побачити і почути пані Франсуазу Кемпф. Вона представниця секретаріату моніторингового механізму Конвенції Ради Європи з запобігання і боротьби з насильством щодо жінок і домашнім насильством. І я думаю, що ми повернемося до стандартів Стамбульської конвенції. Очевидно, немає ще? 2-3 хвилинки. Поки ми встановимо захисту потерпілих, можливо, ми тоді зовсім коротесенько з вашого досвіду, як це вже почало працювати, і, можливо, якісь є тут такі моменти, які варто вдосконалювати. Так, пані Ольго?
Стамбульська конвенція, можна сказати, що 2022 рік став роком болі і страждань і одночасно роком історичних подій. І саме в 2022 році ратифікували Стамбульську конвенцію, і ця історична подія для України була шляхом в 11 років. І ми єдина країна в мирі, яка ратифікувала Стамбульську конвенцію під час війни. Але ми ще й, мабуть, єдине таке суспільство, така країна, яка імплементувала Стамбульську конвенцію норми більшість раніше, чи ми її ратифікували. І це все лягло в закони України про запобігання та протидію домашнього насильства, де підход орієнтований на постраждалу від домашнього насильства, насильства за ознакою статі вже був заложений в цей закон України. Ми криміналізували, це окремий закон про внесення змін до Кримінального кодексу, Кримінального процесуального кодексу, де криміналізували домашнє насильство, де також передбачені всі заходи, які орієнтовані на постраждалу від домашнього гендерно зумовленого насильства. Тобто державний сектор, міжнародна спільнота, міжнародні організації, вся спільнота допомагала цій імплементації. В принципі, це був перший результат для того, навірно, поштовх для того, щоб ми все ж таки навіть в умовах війни ратифікували Стамбульську конвенцію. І далі продовжуємо це робити, тому що там ми маємо низку норм, які не імплементовані в законодавство, як в адміністративне, так і в кримінальне. І зараз і ЮРФЕМ, дякую вам велике, тому що ми співпрацювали з ЮРФЕМ по напрацюванню законопроекту про 8329 про імплементацію норм Стамбульської конвенції в КУАП. І зараз він зареєстрований на початку цього року і вже готовий до першого читання. І дуже дякую вам за ту підтримку, допомогу фахову експертів ЮРФЕМ. Ми спільно з Національною поліцією зробили цей найшвидший крок, який ми могли для того, щоб показати, наскільки важлива нам Стамбульська конвенція.
Дякую. Так, дякуємо пані Ользі. Дякуємо пані Ользі. Пані Ірино, пані Людмило, я думаю, що ми повернемося після того, як почуємо пані Франсуазу Кемпф, яку ми вже бачимо у нас на екрані. І у нас має бути такий, я не знаю, стихійний переклад, напевно, так?
Yes. Can you hear me?
Yes.
Thank you. Доброго дня. Thank you very much for inviting me to take part in the conference. I understand the situation is quite difficult for you today. I hope you will be able to hear me. Is it okay with the translation? Okay. Okay, thank you very much. I just understood that you just spoke about the Istanbul Convention. I'm not sure I understood everything. What I want to do now is just to briefly present you some of the key provisions of the Istanbul Convention when it comes to sexual violence. Okay? Okay, thank you. So, the first important provision of the convention is Article 36, which requires all the state parties to criminalize all sexual acts committed without consent. And the very important point of this definition provided by the Istanbul Convention is the notion of consent, which is central. And the consent is defined as it must be given voluntarily and be the result of the person's free will. And it must be assessed in the context of the circumstances. The aim of this provision is to recognize that certain types of rape or sexual violence remain unpunished. If we have a definition of rape which is based only on force, threat, or coercion. For instance, we all know about cases of rape in which the victim does not react for different reasons, because of fear, of freezing, of the use of drugs, and so on. So that's one very important provision in the convention, which implies a change of model, a change of paradigm, as the emphasis will no longer be so much on the victim to prove that she did not consent, but more on the perpetrator. And what we see in the countries that are parties to the convention is that we have an increasing number of... Yes. Okay, sorry.
Слідомний переклад, бо інтернет нас всіх не стягує.
What I was about to say is that we see more and more states that are adopting definitions, legal definitions of rape based on lack of consent in an increasing number of countries. And I wanted to inform you that Grevio, the monitoring body under the convention, is going to publish soon in September a piece.
Françoise, I'm sorry to stop, and can you repeat your last sentence again?
About the increasing number of states that have adopted legislation on rape, which is entirely based on consent. This is what...
Останнім часом все більше країн адаптували положення Стамбульської конвенції, що стосується інформованої згоди. І, власне, ми маємо такі положення також і в Україні.
And this is improving investigation, prosecution of cases of rape.
Це стосується також і питання розслідування злочинів зґвалтування.
And I wanted to say that Grevio is soon going to publish a piece on an analysis of existing legislations on rape in a number of countries. And I will make sure you get that document when it's published.
Найближчим часом також Гревіо планує опублікувати аналіз дослідження країн, які вже мають положення стосовно злочину зґвалтування, які базуються на інформованій згоді, тобто добровільній згоді постраждалої особи. І Франсуаза сподівається, що таку інформацію також може отримати і Україна і ознайомитись з таким аналізом.
I will also insist on another important provision of the convention, which is Article 25, which requires that states ensure the provision of support to victims of sexual violence.
Також хотіла би зупинитись на статті 25 Стамбульської конвенції, яка передбачає надання допомоги таким постраждалим особам від насильства.
Such support should be provided in the form of rape crisis centers or sexual violence referral centers.
Така допомога може бути забезпечена завдяки спеціальним центрам допомоги врятованим.
And the aim is to provide consistent support to the victims and to avoid that they have to go to many different places, address many different authorities, be re-victimized, and in the end drop the case or be discouraged.
Такі місця мають стати осередками єдиними, а не створювати, але не країна не має створювати додаткові такі різного роду осередки, де особа може отримувати різні послуги. Це має стати єдине місце, що допоможе уникнути ретравматизації такої особи.
And we see that, again, an increasing number of such centers in state parties to the convention.
Ми бачимо, що кількість таких центрів, які надають комплекс послуг постраждалій особі, лише збільшується в країнах Європи.
And typically they should provide a number of services which I will now describe.
І вони, власне, мають надавати таку комплексну допомогу з різних послуг, які потребує постраждала особа.
Firstly, they must facilitate the gathering of forensic evidence, even in case the victim does not want to report the violence to the police.
Вони можуть отримати інформацію від постраждалої особи, що вона, власне, пережила таке насильство, не повідомляючи до правоохоронних органів.
And ideally, this forensic evidence should be kept in case the victim wants to report later on.
Власне, така особа, якщо не повідомляється така інформація правоохоронні органи, така особа може звернутися до них, коли вона відчуватиме в собі потребу і силу звернутися.
The centers should also obviously provide medical and psychological support to the victim, including trauma support, in a manner which is sensitive to the needs of such victims. And this is why there is a need to train professionals.
Дуже важливо, щоб такі центри, вони не просто надавали допомогу, вони надавали її професійно, а також сенситивно, тобто чутливою, власне, до такої постраждалої особи. Задачою не є не надати просто психологічну, юридичну і інші види допомоги, а надати її орієнтовано на потерпілу постраждалу особу.
One point that is important also is that there is psychological and counseling support that is available over the long term, because we know that victims of sexual violence often need support or often go to get support days, weeks, and sometimes years after they have experienced violence. So it's important to have support over the long term.
Хотіла би також наголосити додатково на важливості отримання психологічної допомоги постраждалими особами, оскільки вони можуть звернутися і розповісти про те, що з ними трапилося вже через деякий період часу, не через декілька днів, тижнів, місяців, а може навіть через декілька років. Тому важливо таку психологічну допомогу надавати не разово, а протягом довготривалого часу, періодично.
And there is also the need to provide victims with legal counseling and support to access justice. I kind of understood that you spoke about legal support earlier on. So if it can be provided in the same place where victims go for other needs, it's also helpful.
Другий момент, на якому хотілося наголосити, це надання правової допомоги. І я так розумію, що на цьому заході ви також обговорюєте саме акцент на правовій допомозі, що можуть зробити професіонали і професіоналки в цій сфері. І хотіла б зазначити про те, що отримувати правову допомогу також важливо і в єдиному місці, щоб особа не шукала такої допомоги, а це було дійсно єдиний центр, який забезпечить інформацію про це.
Just to give you examples of some good practices that we see in other countries. In France, for instance, in some places now there is a possibility for victims of rape that go to the hospital or to the hospital to do the reporting to the police at the same place in the hospital.
Я би також хотіла поділитися досвідом країни Франції, де постраждала особа може звернутися до медичного закладу і водночас, звернувшись по допомогу в отриманні медичної допомоги, така особа може одразу повідомити про те, що з нею трапилось насильство, і ця інформація буде далі передана в правоохоронні органи.
Another example, in Switzerland, there is one place in Lausanne where victims can come, get healthcare, but also have domestic evidence, all the forensic evidence be taken and kept, and they don't have to, in order to get that, they don't need to report to the police. That can be done without reporting.
Інший приклад хотіла би навести країну Швейцарію, де особа, звернувшись по отриманню медичної допомоги, може надати інформацію про те, що з нею сталося. Domestic evidence мається на увазі, що докази, які особа могла самотужки зібрати вдома, про те, що було скоєне, власне, таке насильство, і вона не має далі звертатися в правоохоронні органи. Це зробить, власне, установа, до якої вона звернулася.
And the standard of the convention is that there should be one such center for 200,000 inhabitants. So it should be available more or less throughout the country.
Відповідно до вимог Стамбульської конвенції, такий центр має обслуговувати, один центр має бути розрахований на 200 тисяч осіб, тому це ви маєте враховувати також при тому, коли плануєте, власне, створення таких центрів.
Most countries do not meet that aim. In most cases, they don't have enough centers. Only in Spain, a law was passed last year through which a center for victims of sexual violence should be established in each region.
Насправді багато країн не відповідають цим вимогам, вони не мають таких можливостей створювати таку кількість центрів відповідно до кількості населення в своїх країнах. Проте хотіла би навести приклад Іспанії, де такий центр, він створений в кожному регіоні країни.
If I may, I can add maybe a word about the sexual violence against women in the digital sphere. Is that okay?
Yes, it's fine. If you hear me. Yeah. Також Франсуаза хотіла би розповісти трошечки, якщо має можливість часу, пару хвилин про насильство в діджитал сфері, тобто кібернасильство. You have a bit of time, not a lot.
Very shortly to say that Grevio has issued a recommendation 2 years ago to explain how the Istanbul Convention also applies in the digital sphere.
Франсуаза наразі показала рекомендації Гревію, які були випущені пару років тому. І це були перші рекомендації Гревію, де вони висвітлили досвід, аналіз країн з приводу боротьби і превенції насильства в мережі, кібернасильства.
And saying that online violence is just a continuation of violence offline. It's not separate.
Кібернасильство не є чимось відокремленим, окремим видом насильства. Це є продовження насильства, яке насправді є у нас офлайн, тобто в житті. Воно може переноситись в онлайн-мережу.
And it provides concrete recommendations. I will not go now into details, but it provides concrete recommendations and covers conduct such as non-consensual image sharing, online threats, sexualized bullying, online sexual harassment, online stalking, etc., etc.
Франсуаза наголосила на тому, що рекомендації містять конкретні рекомендації і пункти, на чому варто зупинитися і звернути свою увагу. Вона не буде довго на цьому зупинятись через обмеженість часу, але Франсуаза навела також приклади того, яким може бути кібернасильство і де воно може проявлятися.
Maybe I will stop at this stage. I just wanted to stress that in the whole of Europe, in all countries parties to the convention, sexual violence, including rape, is the least reported form of violence. And the conviction rates are low everywhere. And the sentences are also very low everywhere. And this contributes to a culture of impunity and normalization of sexual violence against women.
Наприкінці Франсуаза хотіла би наголосити, що серед різних форм сексуального насильства найбільше, власне, повідомлень йде про випадки зґвалтування, і ця практика є поширеною саме серед країн, які є стороною Стамбульської конвенції, а тому важливим є сама превенція і притягнення до відповідальності винних осіб.
And this is why I think, I mean, what you're doing now today, this roadmap on sexual violence is a very important work, and I wish you all the best. And I am at your disposal for any question and for a continuation of cooperation in the future.
Тема сексуального насильства є доволі важливою, особливо наразі. Я буду рада відповісти на ваші запитання і дуже дякую вам за увагу. Thank you. Thank you.
You're welcome.
Це мій перший досвід. Дякую.
Я дуже дякую за переклад і дуже дякую за цю роботу. Так само дякуємо Франсуазі Кемп, вона представниця секретаріату моніторингового механізму Конвенції Ради Європи про запобігання та боротьбу з насильством щодо жінок і домашнім насильством. Наша, так би мовити, впертість працювати в цих умовах заслуговує на усіляке схвалення. Так? І якщо ви бачили, що там відбій тривоги, все одно ми залишаємося ще трошки тут, тому що там знову заява, чи повідомлення про якісь нові пуски, тому ми все-таки цю панель трошки допрацюємо, але з розумінням того, в яких ми обставинах, я думаю, що я ще попрошу моїх панелісток по колу, так, можливо, вже почнемо тоді із пані Ірини, пані Людмила і пані Ольга, прокоментувати або, можливо, те, що говорила Франсуаза, або додати якісь важливі акценти, які би ви хотіли додати далі. Прошу.
Я хотіла прокоментувати.
Okay, so I'd like to comment, I'd like to inform that last year in March 2022, when we all started gathering at online, maybe someone was present. One of the first events that actually we had by Prosecutor General's Office made, one of the first requests, we requested medical facilities to provide information without giving any contact data, personal data, but for us to understand where exactly, at which location we have a fact of sexual violence, to understand where exactly. And this work gave us some results. We registered certain criminal proceedings, and these were registered not on the basis of the survivor's claim, but what I'm saying here, that right now I'm giving the context of crime investigation 152, 154, these are the articles, but what I'm saying, we had last year, we registered article 438, that was at that moment, these cases. It's registered in any case, regardless of whether we have a claim from the survivor, we will still investigate it anyway. Okay, the cyberspace, yes, I wanted to tell you that statistical data that actually I told you about, that I gave you, these do not cover the cybersecurity sector. Let's say I personally never heard of those facts you know, some high profile facts. It's just a way to disseminate the content, the materials, I don't know, any video files, photo files with use of some malware. So these facts, we have these, we investigate these, but to that statistics that you mentioned, it's not there still in that statistics. Thank you. Okay, I'll just tell you that despite the Istanbul Convention, and we've spoken so much about it and a lot, it's not okay, but it still happens when you come to investigator and he says, investigator in a couple, like, it's not rape. Or he says, someone is holding your bottom, it's not violence. But Istanbul Convention still is not in the mentality. But I'm so grateful that in 2023 we had a big awareness raising campaign before the ratification. Not everybody wanted to hear that, not everybody wanted to perceive it. Now, even in those communities, when you know, remember when people were opposing Istanbul Convention and laughing at it, you know, previously, and they were rolling their eyes. Now people perceive it properly, understanding what that is, that this is effective. Yes. I would say about the problems mentioned by the previous speakers, private and public accusation. Yes, this is a problem right now, because if we come with a public accusation, it's not just the domestic violence, but practically all private accusations against sexual freedom. So we would have more of survivors. Maybe they would otherwise never ask for help. But the third party who sees it and has enough of courage to claims about it. And this would be a justification to respond and to start working with it. I'd like also to say that there is a problem that in our legislation, we don't have criminal, domestic violence criminal offense. We don't have that actually component. It minimizes our potential to see the real picture with survivors, because we take Article 124 domestic violence as a background for it of the criminal code, but we also have crimes related to domestic violence that we may not see. The same murder, you know, in the household, but we don't see it. It will be 152, 115, but no domestic violence. If we had this provision, it must be there in the legislation, because Istanbul Convention tells about it. If it was there, we would see the real picture with GBV and domestic violence in the country, if we had that. Thank you so much. And I just want to say that we have a couple of minutes. If you have questions and remarks from the hall, we'll be so happy to listen. We can respond if someone has. I see a hand, I guess. Good afternoon, ladies and gentlemen. I represent Zhytomyr Polytechnic's Department of Law and Law Enforcement Activity. It's the educational establishment. I am the teacher. I'm teaching future lawyers, future law enforcement. Personally, when I was 16, I myself was affected by violence. It was really horrible. I was afraid to tell to my parents. I felt ashamed. I kept silence. It was domestic violence with my first husband. And it pushed me to become a lawyer later, to study the issue and to bring it to future generations to know how to fight it. Unfortunately, recently my 16-year-old daughter faced, well, her boyfriend, currently he's 19, he committed violence against her in his home. Her friends called me, my daughter's friends called me and my husband, and they informed me that my daughter is beaten. She has signs of beating. And we very quickly came with my husband. We took my daughter. We came to hospital. The doctors were shocked because There were signs of, there were bruises on the neck, 10 centimeters right and left. They were making photos of her skull. But what it was horrible for me that as a mother, I had no right to apply to send a request to law enforcement because she at that moment was 16. Yes, juvenile police was handling the issue. I was explaining, and juvenile police officer explained, saying that, okay, yes, something that you were silent about, now it's for your child. My child did not want to accuse her boyfriend. She wanted to keep it silent. Well, first thing that they told that this is like a medium gravity case. It won't be like a criminal proceeding, but it happened recently on April 26th. Still, it's a pain for me. As a mom, as a lawyer, it's a big pain for me, you know, as for a mom and lawyer. And I understand maybe she still has psychological trauma. She is still going through this. She has calmed down. She's in 11th grade and she's passing her exams. But as a mom, still, as a mom, I didn't have that right to send this request and apply instead of her about this crime. So I was refused. Law enforcement were working with us, but I just described the situation with the signature, but basically no criminal case was initiated and it was not announced at all. Thank you so much. Thank you for this personal case. Thank you for sharing the story. In this space, I guess it confirms, it's a proof that we are ready to talk about personal things. When we try to get some support here, maybe someone can comment. What can we do? What can you do in this situation? Yes, Olga, thank you. Thank you so much for the case. Thank you. It's really good that you actually registered this, that you called the police. The proper fixation, initial fixation of consequences of any criminal administrative offense is a prerequisite that we will lead it to the end. Properly fixing at the very beginning. I didn't see the materials of the case. I can't tell you. It depends on what was written by medics, what medics say of gravity level, because we have administrative and criminal legislation, two different dimensions. If medium gravity, this is a criminal level. It's 121 or 122 article. If this is administrative, then it will not be initiated, I mean the criminal proceeding. So it will be purely administrative then. So we just have to study the issue, like what the consequences, what kind of beating, how did it happen, and when it comes to this private and public accusation, we still have to handle this issue and bring it to the level of publicity. My understanding, this is something I started mentioning at all meetings in 2012 when I spoke with prosecutors, law enforcement. If someone files an application about offense, I'm interpreting Article 214 of the Criminal Code. That's how I interpret it. In this case, medium gravity, physical damage, unregistered criminal proceeding, we go to the court. CPC allows us to go to investigating judge, say that there is negligence, omission of action, that nobody's initiated criminal proceeding, and I would advise you, if you want to do something later with that, please, if you want to proceed, just pick this way, because yes, I've talked about the situation previously, and a very bright example is given. When a survivor simply has no proper legal aid. At the stage of pretrial investigation and later at the stage of any compensation from the perpetrator, if previously you used some legal aid, or if at least you contested the refusal, if you have a right to anyone who is aware, who assumes that a crime is committed, has a right to go to investigator, to prosecutor, and put this data in the unified registry. So I agree with Ludmila. Judicial practice tells us neither prosecutor nor the investigator establishes the gravity at the level of considering. Article 214 says that we have to start the pretrial investigation. For example, if in future, after pretrial investigation, we will have basically the subject of crime, then we'll have a procedural decision and the proceeding is closed, like that. And even if closed and you refuse, you have all the leverage to contest and move further. So you can appeal. Okay, we still have time for one question or remark. If someone has, please. So, ladies and gentlemen, good afternoon. I've been thinking for a long time, saying this or not. Katarina Karmazina from Odessa. You know, in my opinion, as a practitioner, as a lawyer, as a mediator, in law enforcement activity, when we speak, especially when we speak about crimes committed, sexual crimes, I mean, we have two polarities. It's polarized. First, we don't register anything. 99% of cases, they are not registered. And at that stage, even if survivor, man or woman, survivor of GBV, if one goes to free legal aid lawyer, the system says, please prove that you are a survivor. We will give you legal aid if you are a survivor, but prove it. How to prove? No mentioning in unified registry, nothing, 10 days pass, no lawyer. Then if this person has no money, this legal aid is not provided to person. And this is the first problem, how to fight it. I don't know. It's about all crimes. These are not registered. And when you start talking to national police with a cup of coffee saying, okay, they say we have 300 cases for one investigator. Even before the war, we had that. We don't have fuel, we have empty printers, we do everything at our own expense. First thing. Second thing, the other extremity I faced as a lawyer, as a survivor. My question, when prosecution and law enforcement, when they will stop being guided by statistics, stop making these fake indicators and KPIs, this is horrible. Imagine, in a specific case, in specific cases, sexual violence was in a couple. Just imagine, in our country, registering this thing. How can you even start the pretrial investigation? What they do later, this case is broken into episodes which go to different criminal proceedings. And every time this horrible situation, this lady goes every time for interview and it starts again. Every time.
She's telling about that in each episode where different judges are listening to that different members of the court of the trial and so on. But this artificial distribution of powers is not about sexual violence. The huge request to dear speakers within the framework of the powers that you have to pay your attention to those issues and to change something for the better, at least at 2023, because indeed to defend and to represent in such cases is incredibly difficult. Thank you very much. Thank you very much. As far as prosecution was mentioned and the Ministry of Internal Affairs, I'm asking you to comment. Who will be the first, Ms. Irina? Well, first of all, I would like to start with the last question about the statistic data. You see, the situation is that last year, I remember perfectly, all the onlines with the participation of Ms. Katerina Levchenko, and there I was representing the Office of the Prosecutor General, and that happened every day. And I was told, like, please tell us the statistics, prosecutor, name the statistics. That is why today I came with the statistic data. That is with the data that I have and the true to life data. Last year, we did not mention the data. We never used the statistics because it had no proofs. In our work, statistics will always be present. It doesn't tell us, like maybe earlier it mentioned the efficiency of our work. Say so, the number of cases sent to courts increases, we are reacting like as much as we can. Now I'm talking about my workers on local and regional levels. We are reacting and we are controlling the very process of forming the statistic reporting. As for the survivors request, for almost 1 year already, all the system, the whole system had been working on prevention of secondary traumatization of the survivors. And the factors that you are mentioning, that they are not registered, for example, if the person does not know or they cannot just address the court. We have cases when the person writes that it was not registered and we are reacting to that. We are observing that. That is, the person is coming. They say that I was not accepted and so on. Yes, it is not considered on the level of Prosecutor General from the very first moment. We are sending that to prosecutions on the level of oblasts, but this works. But I agree with you that the number of those criminal procedures that I mentioned, they are not true to life. That is what I've been mentioning, and we have to work on that. But in my personal understanding, the main thing is that as of today, we have to ensure not only access to justice, but we also have to demonstrate to the society the real punishment. That is what I called, like this year, we have only 53. And I think that there's a significant number of using Article 75, 76 of the Criminal Code. I would like to talk about secondary traumatization. And now when I'm coordinating the direction of sexual violence related to conflict in my unit, indeed, these issues require secondary questioning and now we, National Police, dear head, our Ministry of Internal Affairs, we are implementing together with our prosecutors the mechanism to minimize, just like yesterday, the prosecutor said at one of the events, we have to make one questioning, just one, and it is like complex questioning in order not to remind to that person extra time about what was done. And I agree with Ms. Irina that there's controlling body for each institution and all the situations have to be considered. If it's not registered, we have to move on. We have to act. And I agree that prosecution, general prosecution, there should be some reaction. And it can't be the mass work. I mean, that all the criminal cases are not registered. It can't happen that all of them are not registered in Ukraine. They are. But there are certain cases that require additional attention of the controlling bodies. Thank you very much. So here it's the last question, the last, so to say, word, and we will end this panel. Irina Kuzina, lawyer. Thank you very much for the discussion. I guess my question will continue it. The standard of proofs in those crimes and criminal violations. Not all of them just have material evidence. I mean, like in Kyiv Metro, for example, or in public transport, we all know the cases. Like if somebody is just touching the back of a person, so to say, in transport, we all know that, but we are talking about criminal violation because they leave no evidence, like they are touching the, so to say, butt of the person. But there was certain case, the victim or the survivor, she addressed, and it was not like the crime, but it was the hooliganism, and there was no evidence, nothing but the words of the victim. I have reasons to believe her because for a certain time I've been communicating with her, but I can also imagine the side of the defender. So there was a person who did it according to the cameras, yes, but there was no suspicion, and the prosecution refused to agree that there is a like suspicion. They say we won't be able to prove that in court. And I'm a person who is also working as a defender, and there is a standard of proofs. But what kind of balance do you see between proofs and such cases? And we see the interest of the suspected person, and also the balance how, I mean, evidence from the side of the suspect, from the side of the victim, because we see that in cases of sexual violence related to conflict, we know that there is higher level of trust because we have some objective reality and there is certain context. But how do you see in the so-called like similar criminal violations and processes this balance for Ukraine in the framework of Istanbul Convention, if you have some opinion? Thank you very much for your question. Indeed, if we are talking about sexual violence related to war, then we can prove that with the evidence gathered. So we have certain evidence about certain military unit that was placed there. We have some knowledge about that. We have some data about the soldiers of Russian Federation who were there. But as for the sexual violence not related to conflict, the same way investigators and prosecutors take into account the obstacles, how the crime was committed, again, where does the person live, how the person communicates with the perpetrator. If you say that the person is known, you just mentioned your case and you said that the prosecutor did not agree, did not confirm the suspicion, but in relation to that, the standards are changed. Indeed, there is certain division between even prosecutors who and how is considering a certain case. If you are asking me if it's enough for me to inform about the suspicion, if I just have the words of the victim, if she is pointing at the person, if I know that the environment, so to say, promoted this fact, I will communicate with a potential suspect. Yes, my procedural decision will be yes, I would like to take this risk and I would send the material to the court. But why do I say that education is really useful when we are all together? Because if they say that it won't just work out in the courtroom, nobody knows. You know, we are implementing new standards when we are implementing new standards all together, beginning with the investigator and with the participation of the prosecutor and lawyer and the judge. We understand the standards that you are talking about. What, as of today, is necessary in the materials? Did I understand correctly your question? You are interested what kind of evidence should be in the materials so that But there is no such list as of today. Unfortunately, the speaker is without the microphone. For me, I hear one more time, as a procedural head, I would like to take this risk. You know, I'm not saying that there is 100% reasons to agree with this suspicion, but I would approve this suspicion. But if a different prosecutor did not confirm the suspicion, it doesn't mean that he did something wrong. We are talking about certain case, right? And I am saying that everybody's changing their standards. And the sooner it happens, the sooner we can answer your question about, like, in this case, what list should we have, and is that enough in order to bring the person to responsibility? Thank you very much. Thank you to all of you. And of course, now I would like to thank our participants, but I would like to mention also that as for the first question that we had from the room about the case related to the daughter of Françoise Kemp, she was listening to us and she said, just a second, I have to open that. But she commented that she has recent practice from May 23rd this year, where the court is assessing such action from the side of the state, and this information will be shared with all our participants today. That is, you will have access to this decision and this information. Thank you for participation in this panel. So we had the participant from the ministry, Doctor of Philosophy and the law, Ludmila Vahivska, a lawyer, expert in criminal justice, member of UFAM, and candidate of legal sciences. And Irina Horban, deputy head of the second unit of the Organization of Procedural Management in support of public prosecutions of the Department of Oversight of Law Compliance. Then it's a really long position, but it's the Office of Prosecutor General. And of course, write recommendations about those joint studies. It seems to me that it sounded a lot of times. Thank you. And Françoise Kemp, of course, representative of the Secretariat of Monitoring Mechanism Convention of UN Council on Prevention of Violence Against Women and Domestic Violence. Thank you very much. And Tatiana Troshinska. Thank you to all the participants of our discussion. I offer to go safely. Fortunately, it is safe in KU now, so we are going to floor number 7 to have lunch. And in an hour at 2 p.m., right, we are coming back to our next discussion panel.
Recording in progress.
1, 2, 3. 1, 1, 1, 1, 2, 3.
дітей. Будемо говорити про те, наскільки наша
We are
правоохоронна
going to talk about how our law enforcement system, system of social protection, and others are adequate to challenges that arise in this context, whether the children are protected, those who unfortunately survive sexual violence, are they, will there be some satisfaction and so on. I would like to invite Ludmila Gritsenko, lawyer, human rights defender, trainer, expert on protecting children's rights. She is the moderator, so Ms. Ludmila. And our speakers, Yulia Ostenko, lawyer, head of the Department of the Protection of Children's Interests in Combating Domestic Violence of the Office of the Prosecutor General. I offer to, general prosecution. There are certain links in order just to shorten the link. So you probably need some things like that in order to shorten. Olena Kharitonova, member of Grevio, monitoring body of the Europe body. She will be online. Oleg Ivanov, lawyer from Eurofem, and Katerina Hulsberg. She is a psychologist for children and adults and a member of the Association of Analytical Psychologists. So I would like to give the floor to virtually. As far as I remember, we have to have also Mr. Pavlov Parkhomenko. Yeah, thank you. Judge of the Parkhansky Region Court of Chernihiv Oblast. I'm sorry. I did not see you in my list. Hello, everyone. I hope that we had a very good lunch. And before we start our discussion, and as we already heard, it is of there's certain emotional tension. The topic is not easy, and we are going to work on that from different sides. As we see here, we have a triangle of justice, so to say, and a psychologist. So, before we begin, I would like to ask you to raise your hands a bit. So please raise hand those who had a delicious lunch. Wonderful. Okay. Now please raise your hand those who faced in your practice directly violence against children. Okay, I see. Thank you. Thank you very much. Raise your hand those who face sexual violence. Okay. Against children. Okay. Thank you. Now raise your hand those who have experience of working with cases of sexual violence against children where the cases have successful ending. Okay. As for successful ending, I mean that the perpetrator was punished, he paid some reparations and so on. At least I hope the process ended. Who's working currently with such cases, but they are not ended yet? Okay. And I have one more question. Please raise your hand those who are ready as of today to mention what are the main challenges for you in this topic. Okay. Are you ready to mention them right now? Go ahead. Yeah, we have such an opportunity to provide the microphone. So before we switch to communication with the speakers, we hear certain challenges from our audience. Hello, Natalia Radushinska, lawyer, member of Eurofem, representing Zhytomyr Oblast. I will tell you the case from my practice. I think that I can tell about that already. I would like to thank you for the challenge. The challenge was that I was defending minor boy who was only 5 years old, and he underwent sexual violence from the side of the other minors, boys who used him. And the challenge was that back then it was a huge challenge because it was hard to lead the child throughout all the process in court to mention correctly what he said, but the case ended positively, so to say, because the perpetrators were punished, and psychologists were working with the child, and the reparations were paid. So, like, there was successful ending. Thank you very much, Ms. Natalia. That is the challenge that you faced, is to lead the child through the system of justice to make it child-friendly to the maximum. Yeah, we had one more hand raised. So a few challenges, it is important to mention them right now.
So I'm from Kharkiv. It's a challenge. What I faced a situation when the lawyer was not aware at all. You know, in the criminal case, when there was a minor survivor, girl, he was proving that behavior before that should be taken account after and how, and regardless of my remarks on interpretation of the law, he was insisting. We had to interview the girl because the accused defense was requesting. Investigating judge was interviewing her. It was really good, but with the lawyer, it was impossible. So we completed the case. We had a fair punishment, but I think for the lawyers, we have to work with them more. Okay, thank you. I will just summarize. If you understand correctly, it's competence of specialists working with these sensitive issues. Yes? Okay. I saw.
Ми готові почути ще кілька викликів.
Доброго дня. Some handle. We are ready. Olga Maslova, a lawyer. I have a case. 11-year-old girl was raped by a stepdad. She's 15 today, and only right now she was brave enough to leave this family and go for her grandmother. So first, Polina was informed. They are very well prepared. They worked very properly. Next day, they had a service. The next day, her mother called the police saying that the child was missing, and the operatives came from a precinct without no gender sensitivity. They don't even know the re-traumatization or something, like they were not aware. Let us, okay, we specify the call. So what is the challenge? The non-specialized law enforcement groups are not aware how to communicate. They are not ready to communicate with the survivors. They just say, we will bring the girl again to the family. Why? For parents to see her, but no, you can't. We will be there next to her. There was sexual violence. Do you have proof that it was there, you know, and the girl was listening to it? This is unprofessional. So investigators and operatives have to be ready as well. But unfortunately, no specific training they have. I heard 3 challenges from you about these. I heard about these. The legal representative's behavior, does it comply the child's interests in these cases? Okay, secondly, actions of legal representatives, and third, certain coordination of specialists and the issue of competence of specialists working with that. Thank you. I saw another hand, another challenge. Okay, and we'll go to. I have 156 proceeding, and both girls were survivors. Close relatives. 4 and 6 months of duration for proceeding. Pre-trial investigation did everything with the kids. They interviewed them in the green room, psychological examination. Mom was interviewed, some grandmas. Working with pre-trial investigation doesn't want to work with perpetrator. We can't interview him as a witness. Maybe he is a suspect. We can't notify of suspicion. We think it's like it's an issue of balance. We do not believe the child. Now, even the psychiatric examination, we stand against it. They do everything with the kid, all the procedures, but nothing with the perpetrator. If we speak about challenges, collecting evidentiary basis, word against word, and trust to kids' testimony, competence and procedural will, yeah? To say yes or no. So signing the suspicion or not. All right, thank you, dear participants. Thank you for giving us these challenges. And right now we'll talk to our experts on that issue. Okay, so is the system ready, justice system, ready to communicate with kids? Educational system, is it ready? Social protection service, are they ready to communicate with kids who are survivors of sexual violence? And I pass the floor to Yulia Usenko. Yulia Usenko is a lawyer, and she is the head of the Department of Kids Interest Protection and Countering Domestic Violence, General Prosecutor's Office. Miss Yulia, please formulate it in the following way, your speech. Show us, we heard the request from the audience, we heard of the challenges. Can you show the audience what is the real situation as of now? What is happening? What do you see? Is the system ready to face kids, communicate with kids, interact with them, and to use these approaches, kid-friendly approaches? Thank you, colleagues. Thank you, everybody who asked me to come here. Thank you for organizing this great event. So many interested lawyers we have with us. People are interested in this issue. And everything we've mentioned at the very beginning, all the challenges you mentioned that we have today in the justice system, education, healthcare system as well. This really is relevant. We can even add some more and more components, and I'm pretty sure these could be presented as well, but the key things, yes, that's what we have. When it comes to reality, saying the justice system, education and healthcare systems, psychological service system, even in schools, saying that these are fully ready to communication, no, I guess, because 100% not. A lot of things are happening in the state, many processes to establish the readiness for specialists to work with kids, but unfortunately still have a long way to pave. If we speak briefly of the processes that we can observe today, an initiative of PGO and MOI and MOJ, we've been working on that Barnhouse, the 4 centers that we actually have in Ukraine, and methodology of green room, opening these green rooms, but without well-trained specialists, those people who are ready to work with kids, infrastructure is nothing. You know, rules won't work as well. They will never work. All right, so for us, for the specialist to be provided with a tool to work with kids, we know that our criminal procedure legislation allows to involve psychologists to interview kids and teachers, but practice shows teachers' participation is basically nothing. And sometimes we have examples when teachers do harm because it's school environment, kids are ashamed later, it's maybe some image of the image of teachers, some pressure may be there. We've seen that. And psychologists, not always it's perfect with them, you know, and psychologists not always act in the interests of kids. So one of the initiatives was to create psychologist registry to give the tool for all the regions and sectors for us to have a chance, and judges and investigators to involve psychologists to investigative actions. This initiative is still too young, you know, and only start launching the competition this year, but we hope this will help experts to use the knowledge, use the skills, practices, and to know how to work with kids. Of course, specialization. What colleagues mentioned, response, to know how to talk at all levels, it's important. The training, the competence of investigators and prosecutors and judges, free legal aid system, lawyers working beyond the system, educational experts, so in all sectors where kids may relate to, social services as well. They directly can be in contact with child, sometimes represent interests of child in criminal proceeding. with this aim for us to build this vertical system ready to work with kids, kid-friendly approach. In PGO, we launched a project to implement international standards in practical activity. There are so many elements stipulated and components. If you're interested, I may tell later about it, but it's about specialization, investigative actions in interests of kid, how to prepare the procedure, how the social services must act, how the experts and specialists should work when legal representative is involved. And when we see that legal representative interests do not coincide with protection of kid, so many standard procedures adapted to applicable legislation. These include international standards, but we can't use them without amending the applicable legislation anyway. All experts are joining us, National Police, MOI, Free Legal Aid System, MSP, Social Service, all the stakeholders, those who contact the kid, those who relate to the kid and work with kids, they are in the process of standard establishment. We've heard about this challenge. Legal representatives don't act in the interest of the child. As a lawyer who is working with, I've been here for 15 years protecting the kids' rights, especially when it's about sexual violence committed in close family, let's say by relatives. Like a stepfather is a perpetrator, mom starts acting in the interest of stepdad, but not the kid. So today, does the prosecutor, or we'll talk about specific prosecutor in a specific proceeding, do they have tools to replace or substitute this legal representative? My first question. Secondly, you're mentioning the decree, yeah? Just some specific. What are the changes? And more effective. Well, you were really correct. All practitioners Unfortunately, we are losing the sound. Yes, we can see that more than 30% we have more of these crimes committed against kids. Unfortunately, 70% are minors. These are. And quite frequently, we have the question if we segregate it based on gender. So many boys, unfortunately, suffer from sexual violence committed by their peers or friends. And family members are the perpetrators. The vast majority of sexual violence cases committed in the circle of trust. Close people, relatives, those people and environment where actually the kid lives in. And we've seen so many situations when mother is acting in stepfather's interests. So much of these we have. Yeah. Yes, we have the tool, CPC of Ukraine, which allows to substitute investigator and prosecutor, them to substitute the legal representative. Another challenge is there. We can make a decision, but who will be appointed? Investigative prosecutor, first it's the relatives the child actually is trusting, the person you can work with who will act in the interests of child. It's important who the child is trusting to. Asking the child, because the child should be heard. This is one of the fundamental principles we have to stick to. If there is no such chance, close relatives live remotely, there are no people who can substitute legal representatives. Social services. Social services, unfortunately, not ready sometimes. I can't say of all, but we have so many cases when they are simply not ready to take active part. They don't know how. And this is the area that should be evolved. We need to give them specific tools. Last year, we had a lot of cooperation, MOI and MSP, to design these recommendations. In the standard, we stipulate the opportunity to maybe define some hierarchy of these staff to teach them how to do it. A legal representative must know the child is entitled to free of charge legal aid, high quality. A child can have a psychologist during investigative action. The kid should not be brought into the courtroom just to sitting and listening, all of that. Kids are entitled to it. It's fully transparent. It should be a transparent procedure. Substitution tool is one problem. Well, this problem exists, but situation is that the other legal representative should be ready to act in the interest of child and explaining the rights. What is the solution? Legal aid. It must be provided to kids, and we also stipulate in our standards the provision which is not mandatory for performance. If not performed, okay, but we will try to oversee for this to happen, giving kids a chance to get legal aid. When there is a competent lawyer who knows how to work with kids in such cases, many problems will disappear. The lawyer will control all the processes happening around the child, the number of investigative actions, the need for these actions, and involving psychologists for it. So many questions. We do hope that this may be a solution. Second, which are the changes? Some of these already mentioned, but just a couple of basic ones, because maybe the participants didn't know about it, like to put the focus on. Just 100 steps. Taking 5 key out of these is hard, out of 100. But if we just mention the challenges presented, working with a kid, the standards stipulate the opportunity to have investigative actions with a kid in that scope when it's not possible to collect evidence another way. They need to use video recording of interviews because Barnhouse, green rooms, not many of them. Technical problems are there as well and many other stuff, but at least video recording the interview, 615, there's a chance to use it. But even if we don't consider this, we have a practice of Supreme Court judges don't want to summon the kid again to the courtroom, but video recording of interview, well prepared with a psychologist, with proper formulations of questions, well planned. It's a chance to refer to psychological examination. Later, we will not summon the kid because that's the way to get testimony from a kid. We already have examples and some practices when psychologists have psychological examinations performed with videos. We have to stay in contact with specialists, acquiring knowledge and skills to formulate the questions properly, investigative actions, to perform in such a way not to re-traumatize kids. Horrible practice of investigative experiments in cases when it comes to rape, kid rape. This is a very horrible practice. It's just, out of common sense. So with the same, we try to minimize any procedural actions involving kid. What precedes that? Well-prepared training and the interview process itself. Safe environment, friendly environment. Barnhouse is not the only green room, the only solution.
It can be any other equipped premise for the child. It can be somewhere in the grandma's house where their child is There's a lot of options, like why the child is afraid, whom the child is afraid of, and where it is comfortable for the child. Also, it includes is freezing. So the cohort that is provisioned about the further rehabilitation of children, because with our questioning, so we just again touch this trauma issue. The child is reliving all of that, and this impacts negatively in psychological term, and further on it is hard for them even to diagnose what will happen to the child. More. So, of course, it's very important in the court process. Here we need judges in this process, and we need understanding of judges that indeed we don't have to call them for evidence, because as it was mentioned about the lawyers, that we have to question them sometimes. But unfortunately, even if we want to start the pre-court investigation and later on not to ask the child anymore, sometimes the judges are reacting in such a manner that the questions asked, they should be just over there. I want to see the child in front of me, and so on and so forth. Yes, of course, it exists. And we cannot teach everyone just so fast. And the most important, in order for all of that to come into life, so to say, it's preparation of specialists, and their interaction is the core, is the essence. Not interaction among ourselves, but interaction with the child who is in this environment. Thank you very much, Ms. Yulia. You know, we can feel that the system is changing and there's certain evolution. Of course, it doesn't happen as fast as we would like to, but those changes as of today, they are obvious. I offer to give the floor to Mr. Pavlo Parhomenko, the judge. He is candidate of sciences, and he is working in Chernihiv. So yeah, so questioning and 225 article and so on, but we would like to begin with what steps are made by the prosecution. That is what we heard, but how relevant it is to implement the approach, child-friendly approach in the courtroom. Thank you very much. Thank you for organization of this event, because it tells us about the relevance of the topic, and we are looking for ways in order to build new approaches in child-friendly justice in terms of sexual violence as well. I would like to share my feelings, how I observe the changes, because Yulia, she presents the policy of the Office of the Prosecutor General, and I'm the judge of the first instance, and I'm working on the regional level. So I feel these positive steps on myself, and it's really nice to feel. And you get great pleasure from that. And of course, we as judges, we are trying, we are doing our best, we are working, we can see even in our participants that we represent different institutions, but I have such a feeling that we are a unified team and we are meeting often, and we are discussing different aspects on child protection. And I guess that the colleagues have been mentioning the challenges previously, and also the issue of specialization. What is interesting that in, of course, like we have juvenile court, and it's only about the cases when they're, like if we are talking about the victims or witnesses for children, then we don't see the an understanding of the policy of the Office of Prosecutor General, that there is a certain specialization. There are special prosecutors who are taught in this manner, and they are working with the children who are survivors. So the fact that this is only being implemented is the issue of legislation, and the preparation is also very important. And the colleague made example that the children were examined and then they were called to come to court, but the practice for the last few years, like 3-4 years, the practice is being changed, and like the bodies of pre-court and pre-trial investigation and others, they changed their approach because they were afraid to examine children with and provide video fixation and so on, and judges were afraid to use such practice. But when, let us say so, from the top, we had such a recommendation like that we use this mechanism, we ask questions, we started using that actively, and so we started implementing Baranahus model, and these are first steps, and it's a very positive practice. But actually, some colleagues are asking, what is it in general, Baranahus? Because it's some kind of foreign word, and we don't know what it means. So in many oblasts already, we are implementing this model. And this is a model which is related to questioning children, victims, and witnesses of crimes in order to further eliminate such challenges and such calls for the child to come to court. And there are certain examples of when we see that practice is changing like step by step, and the positions of the highest court instances are informing. It is important that the higher court also demonstrates with its decisions that this approach can be used, as far as the judges were afraid that we won't question them, and it's important. So that, like, that's important to have a child in the court, but the higher court should mention that the courts are refusing to call the child to come to the trial, and it's normal approach. And thanks to this practice of the higher court, the court of highest instance, we are demonstrating to our colleagues that it can be used, because very often the colleagues, they are addressing us, they are asking for additional motivation, and the judges, they are saying that there is no sense in questioning the child in the courtrooms. That is, it depends on this certain situation. And using our example, we were trying in our court to organize the child-friendly spaces with elements of like child-friendly elements. And I would like to repeat that we are using questioning category. That is, it's not the category where we can conduct questioning of the child. We had such an opportunity, and we are trying to implement that. And further on, we are trying to share this experience so that our colleagues can take that as an example. And if there are some financial opportunities, so these small steps, they are very positive, let us say. So it's important to talk about that first of all, and it's important that specialists who are working with children know about that, they know about these problems, and they are acting in the best interest of the child. So preparation of specialists, I guess those are first important steps, and specialists, when I understand this problem, they will see opportunity of application of international standards in case if there is lack of national legislation, like what can we do from our side as judges? I can, for example, so to go ahead of the lawmakers, and I can make it faster, but I have to provide reasons for my behavior as such, and we need to understand such approaches. This is very important. Thank you very much, Mr. Pavlo. Let us briefly explain to participants, maybe not everybody understands what is 225. That is when, let us say so, the criminal procedure had been open, and at first we have pre-court investigation, the child communicates or interacts via legal representative. So we have an investigator, we have the prosecutor, the child did not come to courtroom yet. And on this stage, there is a legal opportunity to conduct questioning of the child. I like questioning, but still I'm saying that via slash, questioning or examination. So then we can like call the child, it's like organized questioning of the child with the participation of the judge, so that in the future, the child doesn't go to the courtroom, because the pre-court investigation can last for a few months. And for the child, it is important to go out of the contact with the law enforcement system as soon as possible. So this evidence that is created in such a manner with the help of questioning of the child with the investigator and the judge, it is further on studied by court when resolving issue on guilt or other issues of the perpetrator. So, Pablo, tell us, please, what helps you in court to organize the examination of children, and in the context of interaction of specialists, what skills, knowledge, maybe something else helps you? something that we can share with our participants, some certain tools, you know, like this works. Well, I guess what is helpful is to study this problem and to understand the basic approaches. That is, if you understand the basic approach and you know how to treat a child, then you will try to conduct the investigation or to conduct the case so that it's in the best interest of the child. But actually, if we take our example, I would like to share my experiences that we are trying to act as quickly as possible, and I am representing a small region, and we are trying to discuss these issues, no matter whether we have such cases in there or not. We are conducting certain preparation, and we know how do we act like beforehand. So if we have some cases related to sexual violence where there are survivors who are children, even more we are in Chernihiv Oblast, and we had temporary occupation. So we have certain cases like that. So maybe it's cooperation, you know, like we haven't used multidisciplinary team term today. So those are multiple specialists. We are discussing problems with them, and specialists understand each role of theirs, and it helps to organize our work, to manage our work when the case goes to court. So I guess these are the approaches. Thank you very much, Mr. Pavlo. If I understand you correctly, then I would like to draw a line, so to say, under that. This is the message that Ms. Yula mentioned when specialists from different institutions and organizations, that is interagency, interdisciplinary team, so to say, builds its cooperation not among themselves, but also in the best interest of the child. Yes, right. Interaction of different specialists and the judges can say it in such a manner like, we are independent, we should not go to somebody. And I say, like, here we are not violating independence. Like, it can be done in different ways by joint events and so on. We are developing certain strategy. How do we organize our work? And this helps us to understand what kind of principles we are talking about. Thank you very much, Mr. Pavlo. So in this part, we discussed like the situation has already happened. The child is in the situation where violence is present. We already built certain algorithm, what and how will be happening, how to build cooperation. And now I'd like to give the floor to Ms. Elena Kharitonova, member of Grevio, that is monitoring body of Istanbul Convention of the Council of Europe. In addition, she is advisor of the Minister of Education and Science of Ukraine to ensure the equal rights of men and women, and to look at our discussion a bit from different focus, you know, and to say, what can we do in order to prevent on the level of education, on the level of other social services? So, Ms. Lana, are you with us? Yes, I am here. Hello. Glad to be a part of our event and part of this important discussion. Colleagues, I would like to mention a bit, I guess, to switch the focus a bit and to switch from practice to policies, because in my opinion, today it is important to have in public space like understanding of that, first of all, prevention is built on certain mechanisms that exist also in the field of education. In particular, we can prevent sexual violence if we organize in proper manner sexual education, for example. And in these terms, it is very important to have political moment, what I mean, like to analyze how today anti-genderism related to sexual education and how sexual education is used by anti-gender movements, such like stories and mechanisms of anti-genderism are becoming more and more center for scientific discovery, scientific studies, but we don't know how it is spreading, how it is functioning till the end, and how it provides for resistance to gender equality. So we see how this anti-genderism chose schools, chose system of education. As a matter of fact, it's their goal, and they are spreading like serious panic on like violating some gender roles. We are saying that gender theory goes to school, that it leads to losing masculinity, you know, like being the real man and all other things related to toxic masculinity. It causes like not honoring the maternity and so on. So when we are talking about this, of course, there is other option which is figurating especially noticeable, but this anti-gender Russian propaganda line cannot, I guess, be analyzed separately from anti-genderist line of the right sector. And very often we can see strengthening of those anti-gender moves. And I would like to touch the topic of sexuality on the first of all, and how it works, because using the topic of sexuality is very cheap cognitive weapon. And it can be easily used by the machines of propaganda, because sexuality is our, so to say, like part of our identity. It's part of our self. And here emotions are really involved, because easily we can mobilize masses, so to say. On the topic of sexuality and children, it's explosive topic, so to say. And only after Russia's aggression on the south of Ukraine and in the Crimea, we see that this aggression is aiming against the values of the Western countries, and only afterwards it started being qualified as propaganda. But coming back to the topic, we hear that many people consider that sexual education has to be included to educational programs at school, and from the other side, sexual education is a topic which is, so to say, a pillar in our society. It relates to low understanding, and it creates a basis for communication noise, so to say, which is not supported by objective data. And we see how propaganda is included to media content, to mass communication, and how actively and intensely they are spreading really simplified narratives and untruthful information about certain events and so on. And here we have to compare the narratives about sexual education. We remember that Ukraine is moving to the EU, so this is how it looks like: sexual education, human rights, Western values. If we look at Russian narrative, this is sexual education, then bad Western traditional Western values. So we can see how like this middle is distorted, so to say, and they are using double so-called like defense of those spiritual values from the Western values. And also they actively use the concept of the so-called traditional family with traditional gender roles, when mother is in the kitchen and father is in the garage. And also the concept of disturbed parents who are worried what kind of information their children are getting at school. And as a matter of fact, we have the alternative of gender identity, like West is radical and liberal, and Russia, it's traditional values, and they have narrative that, as a matter of fact, these values are imposed forcefully, and they have to preserve the genophone, and they have to protect children from negative information, and thus the society gets an image of sexuality as something that is threatening not only to the child but to existence of the nation in general. And researchers, they see some issues of demographic discourse, which is used discourse about, for example, the nation as power, eugenic discourse, the so-called, and the other type. The first one is that the future of the nation depends on the numbers, how much it grows. Second type of discourse, it's not the size, but the quality of the nation. That is, as a matter of the fact, it's part of nationalism idea. And the third, it's like rationalization of worries against ethnic balance in the society when they make it ethnocentric discourse. And it has nothing to do with modern values of democracy, human rights, and actually the parents are being triggered about the values that they want to teach their children, and they involve into this discussion about education at school, and the children themselves are not participating. There is no understanding how the content of sexual education is built, which is built on the age of consent and culture.
емоційних стосунків між
So related to reproductive health, emotional interaction between relatives, contraception, family planning, and other aspects of human behavior. So sex education is presented as the key subject that today can deteriorate or protect values. This is like a portal that leads us to moral catastrophes. Okay, so it's important not to think like what is spoken, but how the sex education is presented. Anti-gender rhetorics that is actually used to create this anti-Western identity. This is really not just symbolically valuable, but this gives real consequences to social life. Maybe there are no like still serious surveys about it, but anti-genderism use sex education for its political ambitions. And we have to think about other roles that may be played by sex education. It may be an instrument of resistance, and we may oppose the manipulative anti-gender rhetorics. And it's very important to see how sex education can actually, what impact it can give. Interdisciplinarity, critical thinking, interculturality, different communications, and political aspects, really important. Sex education, first of all, it's about emancipation. It's the difference, the autonomy, how we shape our autonomy, sexual autonomy, first of all, is directly related to political aspect. Humane practice. We all different, but we're humans. We all have these peculiarities. And certain anti-discrimination in education relates to that as well. And sex education as a political practice that opens this interrelation between building an educational environment like school, university, kindergarten, and external environment. And it shows that one constitutes another. So it's important with these political steps, possible steps. At one of the previous meetings, the working group at Ministry of Education and Science on equal rights and opportunities, for the next school year, we've been discussing establishment a button at the website of the ministry to notify on violence. But this is not just a button. We need to have a whole mechanism how to respond to these notifications, and this is important. So training pedagogues, training teachers, how to, I agree with my colleagues, in long-term perspective, not just immediate response. And that's where we understand that it's about the proper system of supporting the diversity as the basis for these processes, anti-discriminatory and inclusive, and opportunities and space for all the participants of education who actually are the participants of the procedures. Okay, thank you, Miss Olena. For analytics, for problems, for everything you mentioned. I have a question to you as well, a small one. So you are the member of Grevio. So this is the monitoring body that checks how the standards are implemented, Istanbul Convention. And is this issue raised? Do we focus on kids? Because I understand that Ukraine has, there must be a certain questionnaire because Ukraine will ratify the convention. Is there focus on kids? If yes, can you actually present it? You know that we had the elections in Grevio committee just on June 2nd. On June 19th, an oath will be given. So you have to understand the internal procedures. But I think that this is really important. Yes, Revio itself is not just monitoring body. It's an implementation mechanism that helps states to properly do some stuff, focus on certain things. First general recommendation related to cyber violence, cyberbullying. We talked of that. Maybe something related to work with groups who are specifically vulnerable, like kids who are protected by Istanbul Convention. This may become one of the central tracks we'll have to pick to move. So Ukraine is preparing for monitoring procedure, and I think that our today's meeting is an important factor that shows that there are some shifts. Problems are there as well. It demonstrates the problems. We have to change. Okay, it's not that bad with legislative resources in Ukraine, but the chance to establish this interaction in social practices, enhance service capacity of the state when it comes to expert training, especially for vulnerable categories with kids. This is an important narrative that should be there in the center of activity of all the bodies like Grevio. Thank you. Thank you, Ms. Elena. We've listened to this triangle of justice, but in this triangle of justice, we still had no lawyers, okay? Oleg Ivanov, who is the UrFem support lawyer. Oleg is the lawyer who, in his activity, well, he has this very specific experience, you know? He was handling the cases where women were the survivors of sexual violence when they were kids, yeah, many years ago. So, Oleg, I'll start with a question, like a provocative question, okay? Which challenges did you face? Because again, we heard like how to prove when this is a word against the word, how to prove when word against the word many years ago, okay? What challenges did you face about when it came to proving, especially when these women suffered as teenagers, as children, and after they turned 18, they were like ready to talk about it. What were the challenges? What helped you? Thank you. So the basic challenge is that there could be no case at all. Nobody would even know that it happened, and the person who committed it would never be held liable. And I'm so grateful to UrFem, to Women's Perspectives. How did it appear? Well, it appeared because one of the girls, she was already 18, she had a huge stress, deep stress. She came to a psychologist in UrFem, and they started discussing it. We managed to convince her that this should not be left without punishment. And she was ready to, all the procedures ready to initiate it, but then she had the therapy and then she like ignored it. But after some time, she again had another round of depression. She went to Women's Perspectives to a psychologist, and again, they discussed the topic. And she decided then to ask law enforcement to help and start the proceeding. So it's so good that this psychologist's work, previous work, it allowed us to stabilize the client. I'm saying it, this is a lawyer. When she came, she was ready for this procedure, okay? Second thing, we had to discuss with her, like, what is the criminal process? Like, why do we need it? What will she go through? How it will be completed? And what she wants? What is her expectation of the process? So we discussed that, and we decided to start, like, the first problem was the registration, like how to initiate the proceeding. I'm not saying that we can't launch this, someone does not register. It's simple. We file a complaint, the court's decision, but we started the proceeding. The survivor asks, like, where should I move further? So many years passed. how to prove the guilt. So it helped. Yeah. What helped? Okay, yes, something helped. The survivor was actually ready to open. She told all the circumstances in details. There was a detailed interview, and first, other survivors were there. Yeah. Secondly, we identified that unfortunately, or luckily for us, but unfortunately for the accused, he and other pedophiles, they love to document these things. They love to make photos, video recordings. Even in this specific case, there was, A4 sheets, yeah, like a bunch of these. And he was noting each episode starting from 2008, making notes basically. And we started, in 2019, we started actually investigating. So they are documenting themselves, the pedophiles. It helps us, the lawyers. We interviewed the survivor. She's already an adult, and not enough of motive, data massive for the prosecutor to allow the search. Not enough materials to convince the judge that we need to have the search. What helped you in this situation? Because as far as I understand, you had the search. Yeah, we had the search performed. What helped us, even in this case, I tried this option as audio control of a person in a public place. The survivor tried to start getting some direct talks or mentions. The perpetrator didn't help. Yeah, it didn't. We couldn't provoke him. We also tried to have psychiatric examination and trying to identify if this person is prone to fantasizing, or if this person is affected by other people when interviewed. This examination is about nothing. It's like zero. It's like, okay, there was a conclusion that nobody influenced the person, but it still was very weak. We had a polygraph. The polygraph was very doubtful, gave some doubtful data, some questions that investigation established clearly. It gave some opposite results. The polygraph actually was objecting the facts. The person who goes to polygraph examination may resist the polygraph, may be nervous. Nobody knows what the procedure is. So these body responses, it's not just because the person is lying, but because the person simply is not ready for polygraph. Yeah. So we collected some data massive. We managed to convince the prosecutor. The prosecutor managed to convince the investigative judge. And when there was the search and the active stage of pretrial investigation started, as there were so many kids' lingerie photos were there, all these notes, all that filth was there, even during the search, it was clear that accused starts opposing the law enforcement, don't look here, this is my personal stuff. He started prohibiting us. Yeah, for highly qualified people, that was a trigger for us. We knew that we had to dig there. And in the computer, we found a lot of videos, a lot of photos. 6 survivors in total we had, and 147 episodes. We identified, unfortunately, in this case, we had more survivors identified, and adult women already. For example, identified by others when they came to investigators saying, I don't need it, I'm an adult. Like she says, I am an official, I don't need to have that for my reputation. I don't want to disclose it. I will not file a complaint. I will not take part in this. Out of that massive of data that investigation collected, we can't say he wasn't punished, but it didn't go to the materials of case. What was there in the case as well? During the pretrial investigation in the court itself, the defense tactics was special to discredit the survivors. Like they wanted it themselves. There was a statement in the court. The perpetrator's mother said, she was my bride. She She was the bride of my boy. Like, okay, there were 6. What does it mean, the bride? The fiance. Who is the fiance? Like, all 6 are fiancés? Another tactics was picked. Some episodes which were recorded with the participation of a couple of persons, and one of my clients was already 16 at that moment, and defense opened a criminal proceeding, tried to open, saying that if my client took part in the video recording, she was holding the camera, she's an accomplice. And they were trying to put pressure in that way on us, to changing the testimony, intimidating the survivor. They try to influence, but everyone understands that, yeah, there's a certain interpretation of the article. We all understand what intent is. And this proceeding was completed, was closed, and the defense was not appealing it, was not contesting. So some other stuff, the final result. You were asking, a successful case. We're asking a successful case. I have a question to you. What is successful case? Successful case, as for me, is a case which fully complies with my client's interest, with survivor's interest. One client was satisfied, 5 clients were satisfied, 1 was dissatisfied. During the consideration of case in the first instance court, accused started acting weirdly. There was a psychiatric examination. There was a decision made that he cannot be held liable. Then the medical measures decision was made, yes, to take these measures. We studied everything. So he was accused guilty of socially dangerous act, and respectively those measures were enforced. So 5 survivors say, sorry.
Yeah, so it was of medical nature. Yeah, he was taken to the psychiatric hospital. Yeah, so 5 victims understand that it's not a good place. Maybe it's worse than a prison. There is a medical treatment, and one victim, one survivor says that, how did you work if the person avoided punishment? And I say, like, punishment, maybe indeed they avoided the punishment in a criminal sense, but now he is undergoing treatment, and he is the one who now has illness. He is considered to be such a person, and if we learn that he is well, if it's possible, then we come back to prosecution of this case, to like investigating this case. But it was hard for the survivor. What kind of peculiarities are here that can be applied in order to minimize the traumatization for the survivors? The defense depended on the defense were saying that she has to come for each meeting, for each court session, trial session. Like, you insist on this, you should visit each session, and like the prosecutor supported me, and the judge mentioned, like, why on the like preparation session, or for example in the issue where we are investigating certain evidence, why the victim should be present if there is a specialist person who can represent her interest fully. This is how it is. Thank you very much, Oleg. I have one more small question to you, and then we communicate with Ms. Katerina also. So tell us, please, did women whose interest you were presenting, like that it was long ago, like they had survived violence in childhood, and now they want to put on the responsibility right now on the perpetrator. So it's one of the challenges that we heard of today, why people don't want to notify, why women don't want to notify. That it was long ago, and it's not relevant anymore. So yeah, here we have 2 sides. So actually, when women and women we started questioning them. We were explaining the procedure about the criminal investigation and so on. So one of the reasons was that they forgot about the story, and of course, like there is a certain limitation period. So I clarified the procedure. I just quoted the article, and I managed to mention this. And the other side is that the defense at first was not well oriented, and they've been thinking for the whole process that there are like limitation period has already passed, but it's okay. Like we are not taking special like limitation period, but if we say that there was like 147 episodes, so you are breaking the limitation period of one episode, like this is clear at the end of the court procedure. Thank you very much, Mr. Oleg, for the participants. I would like to mention that in such cases when the child survives sexual violence in childhood age, then the limitation period is calculated from the moment when they became like 18 years old. It's not about military crimes. As for the military crimes, there are no limitation periods. Thank you very much, Mr. Oleg. Ms. Katerina. Katerina Holzberg. She's a family psychologist, child psychologist, and a member of Association of Child Analytical Psychologists. So, Ms. Katerina, you heard the challenges that were here at the very beginning. You heard speeches of our speakers. And I have a question. Like, first of all, there is a child in the background of whom there is such event as sexual violence, traumatic event that hurts, event that violates boundaries. There is a pre-court investigation body who are collecting evidence. How do we find answer to the question whether we should or we should not bring the child to the court? And if yes, then how do we ensure that this contact of the child with the system of law enforcement is maximally comfortable? And what markers would you recommend as a child psychologist to pay attention to? Thank you very much for inviting me, and I'm very happy that I'm the last one that I could hear everyone. I could listen to everyone because I heard education, I heard the prosecution and the judge and the lawyer. And indeed, you know, I would like to mention that the child was ready for giving evidence or for investigation. This simply cannot be. And what I've been thinking of during all the time when I was preparing for the event, our today's event, when I heard you, there is a certain dilemma. What should be done? Because as a person who considers that the evil has to be punished, indeed, I think that we have to have this fair process, and we have to punish perpetrators for such crimes. But I also understand, as a psychologist and a person who has something to do with the childhood, that all this procedure is very traumatic. I've heard already over the year that certain re-traumatization can take place. We understand the consequences of such re-traumatization, and therefore, when I've been listening to Ms. Yulia, I just felt that the measures that are being prepared right now, the questioning or examining the child, it's very important. The first thing which we should keep in mind, first of all, like the child or the person cannot be like examined twice. So that is why the primary examination has to be qualitative, and also you have to use services of a psychologist. But we are all prejudiced. We are all people, we have our own prejudice, and unfortunately this can impact on each level. On the level of the pedagogue who is with the child. Unfortunately, I know very bad cases with pedagogues, when the pedagogues, indeed, they were causing pressure on a child, and they did not give really good characteristics of theirs, although we understand that the characteristics. Doesn't matter if there is a great child, whether child is good or bad, a student or no, it doesn't matter. It's the child against whom the crime was committed. And second, it's when I've been listening about education, and I realized that education of the child in terms of that the child should know what is sexuality. And I'm sorry that the intimate parts, they should not be called with some other names that you figure out, but they should be named in proper way. So the children who know the names of intimate body parts, they rarely become victims more rare because they know how it is called. So there was a case when the child was telling that the stepfather, he said like, he is eating my candies, and it turned out that the candies were the intimate parts of the child, and the child was raped, but everybody thought that it was just eating candies, and the child was calling it like that. So we have to provide this sexual education in proper manner, let us say. So this is important because on the first examination, it can play significant role how the child is explaining, how the child is being examined, and it depends a lot whether those are open questions or closed questions. And it's impossible to tell all of that in one speech, but a lot of things that on each small step can re-traumatize the child and can become a problem. Here, I would like to advise you one book, which is really cool. Elizabeth Loftus, a lot of books on memory she wrote. She herself is a court psychologist, and she's been working a lot with, cases. I don't know, this is a nice word for rapes, but she's been working with rapes. And she's writing books about memory and about how our memory distorts certain events, especially if those are traumatic events. And unfortunately, the story of one book begins with how there was unfair suspicion from adults about the events that never happened, but people visited psychologists before, and unfortunately psychologists help them to recall non-existent memories, because we have such a problem of the memory. We do not recall something that was there, but we recall the less recall about the event, our less recalling, which remains in our memory, and therefore we have to be very attentive. And when I heard that indeed the first examination is the most important and the most significant one, that yes, indeed, the child doesn't have to go to court to the trial itself, and there should be certain situations when indeed the judge can be present. That's what I heard. I'm not the lawyer, but I understand a bit in these terms. I would like to say that it's impossible to have two examinations because it will be a problem for the child. I, as a psychologist, I'm here in order to defend the interests of children and understand what consequences can be there for adult person if they are examined in the wrong manner. In general, you can watch the speeches of Elizabeth Loftus, so that's about that, and it's most significant. Like if you just Google Elizabeth Loftus, it's the most popular speech of hers, you will get interested, you will read her books because they are important. It's a huge experience of the person who is there for a really long time. So we do not have to create some process cases like the psychologists and investigators and judges, and education also, they will be in one general front, you know, against the crimes that, in my opinion, are more important. It is more important to prevent that, because the prevention, as I see that, it's more powerful thing, so that we do not lead to such moments. So I'm really happy that there are certain organizations that understand that without the education, we will not cope. And the only thing is that sometimes it goes not the way we want it to go, and it's important to have good specialists. So probably that's my opinion. If you have any questions, I'm ready to answer. Thank you. Thank you very much, Ms. Katerina. We have just 7 minutes till the end of our panel. And I think that maybe we have some questions from our participants. And I would like to ask you to raise your hand if you have some questions. As of now, I don't see hand raised. You still have time to raise your hand. I am watching you. Thank you very much. Let's do that into the microphone. I will finish my thought and I will give the floor to you in order to ask questions. You know, you named very important thing, Ms. Katerina, to call it with proper name. So violence is existing, especially violence against children, to live and to multiply, so to say, when it is in silence. And when this silence is violated, when children can call intimate parts by name, when they have trustworthy relationship with parents, they can talk about that. Indeed, we are reducing in such a manner the risk that the violence will happen, because the cases that I had, most cases, children did not know what it is, and they were using this substitution of notions, which is hard to prove. Here, I would like even to mention a very important, you know, advice, I guess, to everybody who's facing, who is talking to their own children or who are communicating in certain communities. The child should know if the adult person is coming up to them and are saying any phrase that will contain, like, it's going to be our small secret, that's it. From this moment on, the violence is taking place. So what kind of secret? I mean, the adult person should not have, especially with somebody's child, they should not have secrets. So this is a trigger phrase, and we have to react to this. The adult person came to a child, said, we've got a secret, that's our secret, that's it. Here we will have violence. It doesn't matter what kind of violence, physical or mental. Thank you very much, Ms. Katerina. And I would like to say that in free access, you can buy the book of Anna Salter, which is called Predators, and those who work with prevention of sexual violence, they have to read about that. And parents have to also get acquainted with the book, and lawyers, because the book describes the cycle that is happening with the child, like creating secret and so on and so forth. So a lot of markers are described there that can omit our attention. So yeah, now I would like to give the floor to Ms. Irena for the question. I guess it's a challenge. It's not a question, I guess. I don't take such cases, but especially where the child suffer, I know that I won't be able to work with such cases. So from the point of view of lawyers, do we have to work with all the lawyers? Like if, for example, we have to have this sexual education at school, so do we have to cooperate with all the lawyers? And what is the standard of working with the lawyer or help with the lawyer? Like if he is like working with that. And as far as I know, the psychologists also have their own psychologists for supervision and so on and so forth. So if the lawyer is taking, undertaking this, then how it should be done. So maybe it's the questions to psychologists. Indeed, I agree with you. Each psychologist has own psychologist and own supervisor. I myself have own therapy for 15 years. Every week, I'm not afraid to talk about that because I am working with traumatized people. And I would like to say such a thing that if you cannot interact with that, then don't. I would say a horrible thing, but empathy here doesn't work. Here you can have sympathy, but not empathy. If you are a really empathetic person, it will be so painful for you that you actually will have the counter transference and you will perceive some things. It will hurt, you know, to you. So if you don't see resources for processing such a case, you can just don't take it. And I respect your position that you don't do that. And you need to have a lot of own power and resilience to some things, because system exists also from the other side. It is causing pressure, significant pressure, unfortunately, and a lot of devaluation, a lot of various, swings. When the person wants, then the person doesn't want to. And we heard from Mr. Oleg there were such swings, so to say. So it is worth to pay attention to your own powers. But if you went into such a case, maybe it is worth to process that with the psychologist. And I think that such requests, the psychologists are ready to consider this. I've been working with such a request for sure. This is a good request. I guess it's good that you mentioned this problem. Thank you very much, Ms. Katarina. We will end. And as a matter of fact, our today's meeting is, what is that about? It's about certain legal roadmap, like one sentence from each speaker, certain step to our roadmap in order to prevent domestic violence, sexual violence, and protect children's rights. Ms. Yulia.
Yulia, so first, the first challenge for me is like the recipe, the solution, and the answer to my questions is the readiness of specialists, first of all. If specialists are ready to work, you have to start from yourself. If I work with kids and other colleagues work with kids, you have to do everything that you can to protect the child. Thank you. Readiness of specialists. Okay. And competence. Okay. Prevention. And I do support my colleague fully. Awareness raising in all the sectors is really important. And when with kids and with adults who actually are related to it, like at a certain level. Olena, Olena, okay. Yes, of course, implementation of sex education system and designing it, actually, designing the system and in our educational system, that's what we have to do. Thank you, Elena. Thank you, Miss Elena. And Pavlo? Okay, my idea was to prepare the specialists, to train them. And I would just say that this is a challenge as well. It's balancing between the rights of survivor and rights of accused. And please do not forget that the state has the positive commitment to fight this phenomenon and ensuring that the state is doing that. Thank you, Oleg. Okay, talk to your kids, guys. Okay, be interested in their lives, nurture them, bring them up, and be with them together. Teach them. Just be parents, actually. Do the parenting. Thank you. Thank you so much. Thank you. Thank you so much. And just from my own behalf, the topic of domestic violence countering and sexual violence countering, CRSV countering, especially when we talk about children, it's emotionally charged. But high quality communication at least on that issue and awareness raising, understanding the problem, the ability to call things as they are, to tell the names, and as Miss Julia said, just merging for the kids, uniting for the kids, and multidisciplinary teams. Not just each team knows how to do it, but when they can coordinate and the kid is in the center, truly we can bring this on the roadmap and actually move forward. Thank you so much. Thank you, ladies and gentlemen. Thank you for this conversation. I think that after this topic, we really have to breathe out a little bit and just relax. We need to have a coffee break. 30 minutes, ladies and gentlemen, and then we actually go back to our discussions. And do enjoy.
Які у нас дисципліновані учасники, учасниці наступної панелі. Вже всі на місцях. Так, треба брати приклад з спікерок і теж всідатися гостям, слухачкам і слухачам. Ярино, бери приклад. Друзі, всідаємось.
Okay, so dear friends, take seats. The time is over for the coffee.
І ми зараз розпочинатимемо наступну
And we will start the next panel discussion. And for me, this discussion is a key one, I guess, because this discussion relates to my professional interest, how to communicate the sexual violence cases and sexual violence to society. Because on the one hand, communicating, it's of huge importance. Raising awareness of society on the problems of specific women, that domestic violence exists, and sexual violence, what they experience in their lives, it's possible. They have to know what is sexual violence and violence itself, giving the voice to people who had no voice previously, and helping them to, their cases without society would just float. A Zakarpattia case, But communicating sexual violence cases as a media person, it's hard. Not all journalists know how to do it, and focusing too much on sacrificing, on surviving. It's not the victim, but survivor, using the proper language. Where is the limit? How to do it, but how to avoid that, how to show the suffering but showing it properly, for proper aspects. So Ms. Larissa Dzhansanko will moderate it. She's a human rights activist, Юрфем, one of the Юрфем co-founders. Vira Livko, a judge from Kyiv, she's a member of Юрфем. Irina Voloshina, representing Юрфем as well. Roxana Hera, lawyer, human rights activist, specialist in criminal law and process. Oksana Pavlenko, journalist, blogger, editor-in-chief of Divochi Media, and Veronika Plotnikova. Miss Larissa, please, the floor is yours. Thank you for introduction. The words, we are formulated with the words. Remember the first words. Many people remember the last words, especially of close people. We live as humanity within the language, within the words. Words you can support and protect. With words you can hit, you can accuse of something, you can be very careless with it, you can trust certain words, but you may mistrust the words. You can distort the words. The word can be used against us. How do we communicate the sexual violence issue and CRSV? Sexual violence beyond the context of war. So we will try to talk about it in a company where we have combination of communicative expertise, people from the justice sector and media people. I'm like at the crossroads, there and there, 2 feet at different platforms. But there is a problem when we say, when we speak with standards, but we can subjectify words or use a human as a marker instead of supporting the human and supporting other people. Or we have this attitude to people as to the justice sword, because it's not about us, the crime. It's their experience and that's it. It's their trauma, it's their pain, it's their victory to survive. But society quite often demands not the sword, but these these people who survived it should become like the weapon. Those who have the horrible experience, the most horrible experience of the crime that was committed. So today we will talk about this, how we talk right now, how we communicate, how we articulate. Do we have to change? What should we think about first? What to concentrate? Vira Levko, she's the judge. Vira, quite often judges not personally press releases, we can see different options of these press releases and saying like, okay, we are not commenting. These are mostly cases of closed trials, and yeah. We have to understand how to protect personal data, principles of judiciary when you can't comment upon decision of the court and you don't comment the process. But how then we can reach the balance? When society wants to know, they're very greedy when it comes to knowledge, and people want to see some drama, even like in your. You must be fully impartial, and but it doesn't mean you don't care. So how to build this, how to talk to people, and how to stay professional. Okay, colleagues, good afternoon. So I became a judge in 2017 when this was more like a punishment. A speaking judge, it was a punishment then. Then they were looking for people who, due to certain circumstances, were without certain duties, so they decided to take this burden. Talking to journalists, I was the one. This is a horrible word, was then for us, for judges, for any judiciary stuff. And I analyzed it. Since then, we had a very long way paved. Communication improved, access to media became, access of media to judges, to judiciary decisions became better. Press, service, speakers, speaking judges, it's okay. But yeah, we still have space to improve. When we talk about communicating the sexual violence cases, well, first we have to identify what is the audience, who requires that information. The definition itself of social interest or public interest, it's quite evaluating. What should be socially significant? Information which is relevant for like all people and representatives of all social layers. But we can see that this principle is changing. And what can be socially significant? The information related to functioning of society, which is of public interest. And the indicator of the socially significant issue, the society has a need to respond to certain situation, affected using various moral leverage, legal leverage, whatever. But quite often our society requires information on this category of cases, investigation and consideration, but often they don't notice, people don't notice the inappropriate men's sexual behavior in transport, in public places. We can see that quite often these requests and complaints from women, these are not registered. We've seen social response, interesting one, like we've seen. Okay, women want to have some special carriages. There's an initiative. We saw the response. We saw the comments in social media. So many men responded in an interesting way to that. Okay, society quite often is trying to evaluate the survivor, where she was going, what she was wearing, how she behaved, how much alcohol she had, you know. And I just want to say, we all know about it, but not always we think. The whole system, the whole law enforcement system and judiciary, this is a part of society. So we are not sent from outer space. Everything that we see and everything in the society, we are the mirror. We are the part of it. We can transfer it like everywhere, you know, reflect it everywhere. And lawyers can do the same. They can reflect it. Reflection these incorrect statements, accusations, some behavior that leads to re-traumatization or humiliation of the survivors of social violence. Unfortunately, it's there, it exists. And at the same time, we have to realize that quite often, mostly, the collection of evidence depends on the will of the survivor. So if she or he ready to testify, we spoke that is this person ready to have interviews, polygraph examinations, experiments, many other things. And again, the attention of people is concentrated on the survivor. Is he or she a perfect victim? Like, was she trying to fight back? Was she screaming? What damage does she have? So like everything that we present and something that may not meet the expectations of the perfect victim, instantly this survivor may be accused of manipulating, blackmailing, lying, other stuff like this. So when we speak of criminal processes, these cases, these are so traumatic and harsh for survivors, and extremely. And a rhetoric question is there. Is the society, is the public ready to perceive information about this category of cases, about investigation and consideration, about verdicts, and at the same time not judging the survivor, not being judgmental, not judging one's behavior, lifestyle, activities, partners she had after or before the case? I'll just tell you that not all the participants of the process, lawyers, investigators, some of them are also not ready for it. So we may have cases of this harmful, we have these harmful practices when media are taking some improper functions. They try to act like a court, like a judge, and they interpret the issue on who to blame, like which party to blame. In my opinion, the first and the most important duty of media is informing the audience, raising their awareness, and creating the public opinion by asking relevant questions about relevant problems, focusing on them. And when you have a discussion initiated, journalists have to be the guarantors of objective and accurate information. We smoothly go to the following. Getting this information, they can get it only when they cooperate with state bodies and agencies, in particular the courts. We just have to remember that judges, as Larissa says, they express via their verdicts. Their opinions are expressed via their verdicts. They don't have to explain it in details, clarifying the provisions of law, making public announcements on their proceedings. But despite this, we also understand that, let's understand why our effective cooperation media is important. What I mean, using media and clear, proper language for people to bring it to people objectively and accurately, information, the facts, and what's happening in the court, because mostly, yes, these are closed trials, mostly. Why? To keep this information there, sensitive information. And often public wants to get those details, you know, when they want to have some headlines, you know, bright headlines or big articles on first pages. Media put these accents, you know, they accentuate. If there is no coordinated communication with the court, this may complicate the work. Give another reason to say the training courts fail, but we understand. Okay, what they will read with interest, yes, notifications of press services in Facebook or account of the court, or an interesting tabloid article with a headline. There must be a very, very hot headline, you know, that draws your attention. So with those people who need information, journalists, I'm not trying to separate us. It's not about misunderstanding. I'm also trying to look for a common ground, something to unite us, to work with that. If I see that, yes, the journalist is interested in getting information, not just to make it more clickable or to get some hype, to bring it to people, I think that this is logical.
We have to clarify in details to tell where do we have to pay our attention in order to take into account indeed like complicated legal procedures, because very often this is what we are working with in courts. And I think that such communication will provide the maximal results and we will bring objective information to the society. And also we don't have to forget the fact that we are publishing certain press releases, but we have to get approval from the judge who is leading the case. And it's not always easy, because if we are talking about like prosecution, for example, there are certain subordination, you know, and sometimes we need something to like approve additionally, some formulation or the quarter of the message. So this is what is happening with the judges. So of course we have to provide education for judges. We have to explain the importance of communication in the society to them, because as we saw, any case in each moment can have incredibly important interest in the society. Believe me, nobody thought that this case that was mentioned, is somehow different from other cases of such category. And just believe me, not even with the punishment, because in the register there's a lot of sentences with this kind of punishment. But I would like to sum up my speech that the language which is used by courts and judges when issuing court sentences or some things that they can use for their role, they can use this language, but it's also this right in practice and for certain sides of legal procedure, and therefore simplicity, availability, clearness. And first of all, I guess that is sensitivity of the language of the judges is very important. And then in the society, this fairness will be felt, which is increasing or reducing, and depending on how we think, how we are communicating, how do we treat each other in public discourse. Thank you very much, Vera. Language of defense, language of informing, language of dignity. I would like to address Oksana. I wanted to do that back in April last year. We started such work. It was mostly like a bit chaotic, even though it was organized. We wanted to bring to our colleagues who are working in Ukraine, who are working abroad, how to write and to talk correctly about survivors of sexual violence during conflict. Oksana, what do you think? Did information field change? What is for you a request from the society? What you would like to get more from the legal system, actually? How to build this communication correctly, taking care of people, first of all? Yes. When I was getting ready to this meeting, I've been considering what has changed, and I've been considering what changed since last year, because in media we had lots of problems. How to write about sexual violence, how to write about sensitive topics in general. Last year, after the full-scale invasion, media faced new challenges, and indeed, those challenges became a really high and powerful trigger in order to start a new discussion on how media should work with these topics. And as I think, now we already have some conclusions, and some of them are changing the situation. I can't say that everything is perfect, but I can mention that we are changing and media are changing. If we come back to the last year, then when the first evidence appeared about the violence from the side of Russian soldiers, and of course media and both foreign and Ukrainian journalists, they started looking for the victims in order to convey the story. And I would say that people addressed me and my colleagues, and actually that was a bit scary. And it was clear already that we really need discussion. We need to talk about what are we doing wrong even at this stage of our messages. So from the side of me being a journalist, I understand why West exists for life stories and why we work with them. So it begins with like we need a story, you know, because the society wants life stories. And it happens so that for a person, the experience of other person is important, and we can give really important topics. So we can discuss how to punish the perpetrator, right? But we are facing the fact that between the emotion and looking for fair approach, we have to have this balance. And at the same time, we got acquainted with a strong project who are providing help to those who suffered from violence. They have this principle, and I like that. They are providing medical aid first and then psychological aid if necessary. And then already, like anything, if the person wants to speak, if the person wants to make their story public, they can do it. And it seems to me that for media right now, back then and right now, it is very important to take this principle, I mean, the priority when we are telling the story of the victims, of those who suffered or some violence related with war. Safety of person has to be first of all, the right of a person to receive aid and to preserve their personal data. When we were writing this document, also on Divoce, there was this material published. So it was appropriate back then, and it's still appropriate about how to communicate with those who suffered from social violence, because for many media representatives, it can be a new topic. And what we can see that many people are coming to journalistics, they start working, and it's the document that can help them even on the in their first works, like how to write about that, how to communicate. And in some time together with the Human Rights First organization, we translated this document into English, and you can download that on the website of their organization in a convenient PDF format, and also just get acquainted with that. And it seems to me that we can share our experience also with foreign journalists who are working now in Ukraine. There's a lot of them. Very often they are working via fixers, and very often fixers are people who probably before that had been working in media, or they don't have enough media experience. So those are totally different situations, but mostly they want to receive this information. They want to understand how to work with these stories if they never worked with that before. Or also if a journalist is working with a sensitive topic, they have to understand that they have to remain a person, and they have to understand that there is like the recording device to the other side, like the camera, for example. And it is also important that the journalist should not be the investigator. They should not say like the rape cannot be the subject of journalist investigation. We don't have to be psychologists. Like we don't how to ask what do you feel, and so on and so forth. And I think that in any cases it might become better. We are also talking that the journalists have to cooperate with the legal protection of the victims. We have to talk with lawyers about what kind of consequences might be there. And actually journalists are obliged to discuss the consequences of publication, or like, you know, what can be applied to the victims. If we come back to mistakes that are made by media workers, the main mistake is the mistake of aim, like why we are doing that and why we are doing it like that. And if we ask ourselves this question, then all those things, all those details, emotionality, we understand that it's not needed because mostly this has no aim in the text. But again, it can cause trauma to people who are going to read, who are going to see that those people who survived violence, or they can get the trauma of the witness. And again, such details can impact the personality, meaning some details, even if it's an anonymous story, the details, how many children are there, where their parents live, and so on and so forth. This can violate the privacy of the person. And if we come back to the aim, like if we are talking about the rape and the military conflict, we are talking that the rules of war are being violated and our peaceful population is suffering. And indeed, those are crimes and the criminals have to be punished. In order to provide this opinion and to give details, we have to explain that to international community, but again, like we have to provide the text emotionally. Also, if we are talking about civilians and not military crimes, then here the same thing is happening. We have to think about protection of survivors. We have to think about their private data, and we have to talk about how does legislation work, in this case, how to receive the protection, what is violence and what isn't. And in order to bring these topics for discussion, we don't have to mention everything in detail. Today, the case was mentioned about the rape on Transcarpathia, and unfortunately, it showed a lot of mistakes in media. Like one of the TV channels was taking interview from a father and grandmother of the victim that directly mentions her private data and personality of the person of this girl, and the channel wanted to make a talk show dedicated to the crime, but thanks to public opinion, it was not done. Again, coming back to this, we see a huge mistake in that in media very often touch this topic, that the accent is on the person of the victim, person of the perpetrator, not on the crime itself. And it's very important for the media, because when we are retelling the story, when we are working with the stories, then it's important for us and not to omit the most important thing, that the crime happened, which is the base of what we've been talking about. And as of me, this is the most important. And even though still we have clickbaits and headlines, and unfortunately, they are going to exist forever in the internet, like those headings. We have to understand that in addition to conscious media, there are websites that are working on clickbait. I mean, they can even not be considered media, but still, like in media, I see that it grows, and mostly thanks to such events as today, and thanks to the discussion that we have, we can discuss these things. We can discuss them in different circles. We can discuss the problems with lawyers. We can discuss it with psychologists. We can find some joint points that will help us to tell the story further on, because our task is to tell stories, and we have to get information from that. And therefore, together, we will continue our growth. Thank you very much, Oksana. I just want to inform actually the legal environment that this year, for the first time, when we had the journalist conference in Bucha, we were talking about ethics of information and materials concerning, in particular, military crimes and crimes related to sexual violence. And it was quite an open discussion. And we have that in movies and articles and TV format of materials. And that was very good discussion, and we had a few positions there, but at the end, all of us brought those positions to the fact that, first of all, we don't need to take the story of the victim and her nearest circle, and we have to work carefully with the gift that is given to our informational hands, and we have to clearly understand and clarify to a person about the legal and information consequences of the fact that this story will go to the hands of the society. And this is very important. I would like to continue this topic with Roxolana. Actually, we're here is a place of lawyers and defenders who are working with this topic, and they are conducting like legal support to those who survived sexual violence. I actually even via my discussed story about the rape on Transcarpathia, we are coming back to that all the time. So you know there are such cases that are coming, make you come back to that. So I finalized the work that I call it Instruction on Information Self-Defense. Actually, for the fact that not only lawyers, but also the victims and their loved ones understand what is expecting them, both positive, neutral, and negative, when you open up to media. And it's not just to open to the media, because we are all media workers, but it's like you become open for the society. You are very open with your pain to society. And actually, I was trying to create the algorithm of what can happen, the issues that can offend, the issues that questions that you have to answer before going to public discussion of this. And it seems that it is important, very important from the side that many people and many sociological studies are speaking about this, that information campaigns, information sharing on case help or promote the fact that the case is considered, that it's not abandoned. And here, by the way, the role of the lawyer, I guess, is the leading one. Yeah, thank you very much, Larissa. Indeed, this case and such instruction, they are really necessary, because the lawyer, when taking, when they decide to stand for the interest of the person, they become part of the story, or he or she becomes part of this story, and they become such a, you know, a bridge, which is communicating with the family, as far as this is a case of the whole family. And they are communicating with the victim, and they are setting up this kind of connection. And very often, objectively, nobody is ready to the situation of violence, and even less people are ready to talk about this to media. People who suffered, people who had sexual experience of sexual violence, they sometimes get isolated from the society, and from the other side, they have such a temptation to go to the media, and they get some desire to tell the story, to make it more visible. And in this story of involvement media, it's like about the poison, you know, because one thing can be both poison and cure depending on its dose and how it is emitted. In case of the advocate, you have to understand that we need to understand how to talk, what do we say, and whom do we say it to when we are talking about the committed crimes. And here we have rules of advocacy ethics, and one of the principles is the priority of the interest of the client. And in case, for example, when we have some sexual violence about the minors, we have to understand who is the client of the lawyer, not the legal representative who is concluding the agreement, but that minor or the child. And we have to understand that very often the lawyer can face such challenges when the legal representative, with their actions, they can become a threat for the interests of that client. Because, again, there are some temptation from the parent side to give interview, to take part in some talk show or in something, just not understanding, as I've already mentioned, as my colleague mentioned, the consequences, potential consequences, not only for mental condition of the child, but also for the case in general. Therefore, some lawyers who are working with such a category of crimes, they even the agreement that they conclude for legal aid, they add special provisions on the fact that any communication with the media, provision of information are given if they received the agreement from the lawyer. So this is the kind of like practice that helps to discipline that. And lawyer becomes a person with whom the parents of the minors or victims, or the victim, him or herself, like it can explain a lot to them in terms of legal procedure.
Because as we understand, the notification of the crime is not even the start. It's just like an announcement. Many survivors, they don't know what the process will be, what challenges will be, and at which stage what may be harmful. So it's really important to have this communication, how to talk, how to talk. Remembering the lawyer's ethics principle, confidentiality, lawyer must also, while expressing himself, a case where I am defending, representing a minor survivor, there were like almost all communication errors made from the media because media, unfortunately, decided to make the story a clickbait story, typical one. Emotional, without even thinking about the consequences for the kid. While interviewing relatives and teachers and at school and making, in fact, there was no single chance for a kid to save the confidentiality, to keep it, to secure it. So lawyers at least have to take those preventive measures for relatives and legal representatives. Limiting, okay, not limiting, it sounds too harsh, but explaining what limitations are necessary for the sake of the kid, for the sake of the client. Secondly, who to communicate with. It's really important for the lawyer to be attentive when it comes to information hygiene. If this is a very important demand of people for information, public demands that. But if it's a talk show, if it's like how to say it correctly, tabloids, okay, the mass media who are not interested in positive consequences, yeah, for defense, for protecting the rights of minors, but they're more interested, tabloids really want to make themselves more popular, or channel if it's a TV channel. So we have to study very accurately those demands that lawyers get, because if this is a high profile case, then we have this tsunami of requests, and in this tsunami of requests, it's really important not to drown. It's important to pick carefully which comments, to triage the comments, unify these. So what should lawyers say? Again, coming back to principle of survivor's interest priority. Everything, all the communication must be directed at protection of survivor's interests at the best. For the case, it's really excessive. It's not necessary to support the interest The information is not necessary on personal experience, yes, of the survivor. It's not necessary to give information about one's marital status, parents, upbringing conditions, school, like relations with peers. But these are the questions that 99% of these are received by lawyers who work with these cases, okay? What the media are interested in. So we have to plan carefully. It's like not a lawyer's job, but when lawyer takes the case, there's no choice. Additional hours, working hours, and it's a separate task clearly to plan the messages, because each of the cases when there is violence against minors in particular, we have to communicate it from the standpoint of all kids protection, not like a specific, it's not even for a specific child, but all the children. This message should be related to specific gaps coverage in legislation, focusing on imperfections of procedures, or focusing on which imperfections are general or specific, what led to violations of rights of minor survivors and the right to defense, for example. That is how we will start solving the problems without stressing too much on the survivor, they're putting the pressure and allowing the kid, if it's about the kid or an adult, to save the confidentiality, secure it, to keep this chance to live your life without stigma, which unfortunately is still there in the society. It's blossoming, I can say. And in my opinion, it's a huge responsibility for the lawyer, not even less responsibility than a high quality presentation of interests and defense. Yeah, thank you, Roxolana. Truly trying to keep the private borders of every person who is vulnerable, trying for the person to keep its integrity and to stop using this approach when her life is just broken into pieces like her body. Quite often, we're so careless when we talk about it. We don't think when we talk, or when we when the person is confused with all those procedures, one doesn't understand. I really loved your statement on the announcement when everything starts. You don't understand, you just read it like, yeah, you read it like a manner. You don't understand that you read it and you will be there on the stage in the spotlight. It's a new challenge. You won't be like an observer, okay? It functions in a different way. So I just want to, together with the audience, I just want to go back to second panel when Christina Keith was showing the survey on how people evaluate our defense job, activist job on the issues that we talk about in the indicator. I want to remind you, over 70% of people want to be informed on how these cases are investigated, where to go, lawyers' role in the process. What can I ask the prosecutor? I go to you, Veronica, because you'll have a coordination center. You actually have it to support witnesses and survivors. You will have a communication component of people who will be referred to. Someone will maybe even use them, and you have to talk about something that you mentioned, like who you are for people. And I can't also, I want to use the occasion, and I just want to remind you of the case, your case, that communicatively promoted you to think Kaharlik rape, when police officers raped a person who was asked for interview, and they kept the lady in the interview, and what happened later. We as society, we were discussing it a lot. Yeah. Right now, we already have the first verdicts announced. We like forgot about it a little bit. It faded. Because another problem of us as people, we do understand the entry point and remember the entry point to the announcement. But what the final verdict is, oh, we just have another drama today, yeah? Another clickable thing. So it's something that relates to all of us. Thank you, Larissa. Definitely, I'd love in my speech to, you spoke of 2 feet, 2 platforms. I'll talk about my platform, the previous one your colleagues are handling right now, and the platform, the future one, the next week. I do hope that we'll cut the red ribbon, you know, to launch the processes. Okay. So continuing the Kagarlik story, because today publicity was talking about the latest proceedings, these horrible war-related crimes. We know how many juvenile cases we have. The story of Kagarlik is the story, a professional story. This is about building the system and institutions. I just want to say a couple of words about my background. Before I had an honor to lead the Coordination Center of supporting the survivors and witnesses of war crimes. Right now it's for the war crimes, mostly that. In the PGO for 3.5 years, I worked in so-called in anti-torture department, as they know it. Protecting human rights in penitentiary and law enforcement. In this case, our prosecutors don't like this word, but this case, these cases were related, and in the moment we can talk, because this is not even, it's the pre-trial, not still the trial, not related to sexual violence committed by the state officials. In penitentiary, or where there's full control, like what happened at Kagarlik, sometimes we talk about sexual violence committed against men, and this is a special case. I'll just say a couple of words. So the story about Kagarlik, I can tell you that we were leading it in our department from the beginning to the end, and right now we still handle that because we hold only 2 people liable out of 5. The executive, direct executive, but it was revealed. But still, it couldn't be possible without leadership and manager knowing about it. 3 of these are now in armed forces. We will still have this case handled by department. We do not lose it. The communication entry point, for me, this is a story how the approaches were changing in prosecution. Sometimes the media approaches were changing. We as society, representatives of criminal justice, how we were affected by the start of full-scale war. And that flow and wave of information and violence and, you know, and right now the unacceptability concept is looking different for us. Because 3 years ago we had those events in Kagarlik precinct of police. I'll just tell you that even in encyclopedia we have the sexual torture. The photo of what was happening should be exemplary for this case, you know. When we spoke about the publication of data on verdict on the website, we argued with our PR people on the photo not to affect the survivor, how to select the proper photo. We mentioned clickbaiting today, not to make it clickbait, but just like to be a symbol of horrible phenomenon. If you're interested, you can see what happened there. As Vera said, as Larissa mentioned, the judge is using the language of verdict of a court decision. Prosecutor has a little bit different. Prosecutor is using language of documents and directly to person, directly to survivor. The prosecutor talks to the accused, the suspect, to everyone, all the subjects. Moreover, this is the story when you can easily excuse yourself. I have a burnout. I had emotional burnout. I had to achieve the goal of proceeding. I had to get information. In some way, I did it. And that's it. We found out about this very quickly, and for the first few hours, we had regional prosecution. A couple of hours, PGO was there. I speak of the guys because at that moment, we mostly had males there, you know, as managers. So why I speak of gender? Because they were gathering. We were discussing with which words, what to use to talk to survivor for her to continue talking to us, for her not to close, because when we heard the primary information, many were just holding, you know, their heads in their hands. When the prosecutor and investigators were handling the legal work, the field work, this story everybody started thinking of survivor as a resource, I mean, the media, to get some profit out of this story. I'm not talking about all media, you know, without exception, but this is the story like, okay, you can say I have a social demand, but you can do a lot of harm with it. The first communication attack, a couple of hours, we're trying to hit these attacks, and we've seen in which way we'll present information to protect the survivor, because I think we had 11 lawyers claiming they were the lawyers of the survivor. And at that moment, when it was finally handled with the lawyers, you know, it was clear. Vera spoke of that we have different communication approach. In the office, we have communication service and prosecutors handling the proceedings. Just like now we have it. Each sentence is approved because prosecutor in that story, he or she, there are two issues. First, one must prevent traumatization, victim blaming on the one hand. On the other hand, social demand. If you don't respond to public, if you don't give information, media will do it for you. People will start inventing, you know? And there is, of course, the presumption of innocence. We still, if we have no verdict, we can't say that this rapist or this murderer committed this. We can't do it. So the big fish, do you remember? One of the heads of the police agents were trying to step away from it, and I hope we stepped away. This was mini communication strategy. The department was building relations with media, and this stories that every time before coming to talk shows, even because at that moment we couldn't do it like with other cases. We couldn't prevent it, you know, this discussion of details. This was the best idea to protect the survivor. As prosecutors, we understood what she would get there in interviews, what she can expect at examination. About examination. Those who are practitioners, you understand that in these categories of cases, examining genitals, intimate parts, and psychological examination if we had long tortures. So with experts is like, okay, experts has two tasks. One should get information to put it in the opinion. And again, you have to avoid re-traumatization. What was then? What was later? Like the society demands, why there is not verdict? Where is the verdict?
A few weeks after, like why it was written that please examine this one and that one. I call it a voluntary, like helpers, volunteers. It's good that there is such interest and so on. But for us, it was also a story about building our boundaries, about where is there the boundary of the prosecutor's work or the work of criminal justice, where is this story in order to hold attention on really like bad events, and where is the story to earn certain social capital. What did we do in order to not just to make the victim secure, but it was not the story about the one case, one example, but it's about highlighting such a thing, such an event. So we created and we held a meeting of law enforcement agencies, and a lot of those events, a lot of those measures that were confirmed back then, now in 3 years, they are helping us greatly in the stories about the full-scale violence already. So that was a story based on one story, indeed, which was scary. So we wanted to highlight and mention the whole event, and also to attract the attention of media and start building that system, because now we can say that like we have this built more. But what happened in 3 years? There's a note that, and she highlighted that we've been expecting this kind of challenge in more than 10 years. I think that the society can confirm we have minimal number of cases and torturing, minimum sentences with the, so to say, like prison sentences for the law enforcement agencies and others. So it's the first sentence for authorities, for policemen who are guilty in such events, and it's the maximal measure, because it used to be like 12 years in old edition, now 11. So we think that actually it's a story of legal success, because on this we can continue building that. So in media, in comparison to what used to be there, we did not receive such things. We were going to the information field. We were initiating these publications. Indeed, later on, it was widely spread in different media, but I dare say that it was when prosecution went to this communication platform and was trying to, and I think that they did a lot in order for this story not to remain only in the newsline, you know, somewhere with likes at a certain period of time. We had to remember about that, and the policy of our office is that the policy of zero tolerance to torturing, to any kind of violence, especially from the state representatives, is the absolute norm which has to be there. It's very easy, again, to just go about the measure of perceptance of this, especially if you see that every day, like prosecutors are working with that. Ms. Irina Didenko had mentioned today a lot of those cases. So this is like, if we are talking about communication in general, this is present, but there is delicate thing, which is communication inside of the case, how prosecutors are communicating with the victims, because in our system for a long time, we've been seeing that, and we see that that the victim is the most unprotected person in criminal procedure, the most unprotected, even when we are talking about my favorite practice of the European Court on Human Rights. Mostly this is a story about violation of convention on legal positions about the suspect and not the victim. And actually, I gladly perceive that the Cabinet of Ministers of the Council of Europe adopted a new resolution, which is about the victims. It's a long read, but it's a useful long read. And moreover, I truly hope, it's my responsibility also, that this will be implemented also in work of the coordination center. And I would like to mention that a bit later. So as for the communication inside of the prosecution, it's incredibly important because in these categories, it's a huge number of examination. And actually, it's a story about, first of all, for the prosecutor, when they are thinking about their examination, they should make it efficient to the maximum so that we don't have to make that for the second time to re-ask and so on, expressions, because this, again, we don't know how to talk about certain things, not with the internal everyday language and not with the language of physiology book, or anatomy book. Because again, coming back to the things that happened, my boys, I can say so, they were mentioning yeah, we know that it is called like this, but how can we substitute it so that we can write that in the protocol? Okay, look, there is such a word, there is such a word, and also there is such a word. Okay, we will consider. Because we need to write it in such a manner so that it can be spoken in the court. Okay, good job. I can't say that it's some kind of a funny story, but this is a life story, and it continues. As for the communication, as for the word selection, because again, as Miss Larissa mentioned, I'm sorry about such a number of times when I mention you, but again, this word remains in the documents, and then these documents, they remain long term. So was it built? We made decision after we recorded the emotional reaction after the sentence was announced. So many people thought that Savchenko, she'll be released in a few years. Then, why the head of the regional unit was not pushed to the jail? So, and other issues. And in a few days, so we discussed that with the communication specialist, and we communicated with the prosecutors, where they were providing answers in a very simple language, not with the norms of the law, not with the number of the law, but he explained why it is so, what is going to happen next, what we are expecting, what we hope for, and so on. So with such reaction, we had certain moments, and we hope that this policy will continue. But this one case on which actually a lot of things were built or based, and it was an opportunity from the thing that happened and could not be contained within the our understanding. If you are talking about the human behavior, then if we take off the emotions, it's built into a huge system. But now, as it is said, coming back from the past, because now the department is going to make their work without me, but we are coming to the thing what is going to happen in the office of Prosecutor General in communication, and how in general with the victims and witnesses of military crimes, as well as victims and witnesses of military crimes related to sexual violence during the conflict. This idea was developed and so on and so forth, but as it is said, nothing will stop the person whose time has come. We think that it happened. Now we are creating coordination center, which is going to take care of the issues we are covering. So they have a really wide mandate, so to say, and it's a story that the witnesses and victims should not be there, so that they have someone who is directing them, because for ourselves, we all understand that no matter how it sounds, maybe not really in legal language when we are making the roadmap of the central development, first of all, it has to be a person who will go down to that personal hell where the victim is living, they are going to be there with them. They will, if possible, raise it to a certain level in order for this to become possible, and like that it will return to them, so to say. It won't be revenge. I won't speak in like scientific language. I hope that soon we will have that on this website of our office, like the applications and so on. And using the opportunities of this platform, I would like to say that we open the selection to be the coordinator of the selection center, and we will be really grateful for expert support. And your fam is doing that. Last week we had a big meeting with part of NGOs, and we will be really thankful to represent if representatives of professional community will get involved in work of this center. So I'm sorry, maybe I am taking more time than needed, but I had to tell a lot of things, and you can read much more. Thank you very much, Veronica. It's a really well discussed case of communication within a very complicated case, and you mentioned that we have to highlight like the general tendencies, the general events, not to make a Prometheus out of person, so that somebody is eating their liver in order for the whole humanity to be okay. I really like such generalizations, you know, when at the cost of other person, people think like, okay, I will get rid of some fear, I will avoid all of this, I will read something scary before sleep, and maybe it will become easier or not. Okay, Irina, I would like to invite you. Generalizing the whole experience, a lot of communication, and our organization is working with the victims and with the lawyer community, so to say, with the judges, policemen, prosecutors. This is gender sensitive language. We are talking about that thoroughly during war, during peace, at war, at peace, and military crimes, ordinary crimes. So we are talking about that all the time. How do we speak about it, in your opinion? Thank you so much. I have very responsible task. I have to try to sum up. Actually, a lot of things that I wanted to mention today were already mentioned, and I sit and I think that like where there was a wrong turn, you know, because analyzing the topic of sexual violence in last 1.5 years from a clear reason, because it's one of the weapons of Russian Federation in war with Ukraine. And in some moment, the sexual violence as a military crime cannot be in our society separately from the problem of sexual violence in general. Well, analyzing these 1.5 years, we are talking all the time about the victim-oriented approach, but why? For a part of the professional communities also, it is like the victim-oriented approach looks like the analysis of the life, of experience, of obstacles that are surrounding the victim and past of the victim. Now it's, I guess, I'm wondering, and I guess it's the knot that we will have to untie in the future, because when we encourage media communities, professional communities to talk about the problems of sexual violence and think about the interests of victims, we have to remember that we are not talking about their life, not about their experience, not about the situation that they are in, but about the huge problem in society, which is the problem for all of us. Unfortunately, there are people who are living this and much more because they are suffering emotionally, physically, and so on, but still it remains our joint problem in our society. And Irina Didenko, we recall her quite often, she said that we are not doing that till the end. She meant, actually, the fact that the number of cases of sexual violence related to war, it's not according to real I think that we are not working to the fullest for many years. And of course, I guess one day we will be able to say that it's good that this horrible situation, during this horrible situation of war, or this situation of war, horrible situation we used for us as in order to make something like sexual violence, but it did not appear in these like 1.5 years, but it came up, so to say, in these 1.5 years, because there always have been victims. There was a lot of sexual violence all the time, and now it's incredibly difficult, and it's even weird to hear sometimes the sayings that, oh, there's so much sexual violence around and it arose in recent years, but no, it always existed. We just started talking about that. And in a communication sense, for a few months, we've been working on that, because even in ratification of Istanbul Convention, colleagues shared that there were really weird things related to like, oh, you see, the Istanbul ratified and the number of domestic violence is growing. Well, you know, this configuration for me personally actually is beyond my understanding, but nevertheless, we have to remember that such understanding about the world continue existing, and we really want that we can cope. In this situation, we cope and we bring people back, that we just started talking about that. And even if it's unpleasant for me, or if I don't want to think that in the neighboring house or on the next street or in the neighboring town, sexual violence is taking place, I have to think about that. Because now we are in, I guess, in such a point of development of our society when we have the ability to do something with that. In our work, of the communication direction of Eurofem, we are trying via legal categories to speak actually about the change of the paradigm. Last year, our educational center was making a huge course on military crimes and part of sexual violence, and a lot of international criminal court cases were there. We are trying to take out of those cases some points that might be key in our communication. For example, we've been talking about the environment of forcing. This term haven't existed till the last year, at least in my work for sure, but actually there we are talking like if it's the environment, forcing environment like occupation, there cannot be any consent if this is occupied territory. Like if the army of the enemy is there with weapons. And for many people who are not involved in investigation of war crimes, this is a key thing. Because when they write, like, oh, she went to the cafe with them on the occupied territory. Oh, they had some relationship. Those cannot be relationship in our classical understanding, because that was the occupation army. And even if they did not put the weapons to her head directly, it doesn't mean that there was consent. So it's one of the communication knots that we are trying to use. We are trying to explain how it is different. For example, in the context of military crimes, I mean, like sexual violence, how is it different from other types of violence? Or what was mentioned on the previous panel in terms of sexual crimes against the minors. For example, the person who 10 years ago survived sexual violence can think like, what's the sense in addressing? What's the sense in talking about that if 10 years have passed? And correspondingly, the like when the person became like 18 years old and some minimal chance of punishing the perpetrator to make so that the violence does not continue against someone else, it exists. But the person understands that a lot of time has passed, and they don't pay attention to that when we publicly speak about the term like of like statute of limitation, that it comes only with the when the person becomes 18 years old, then it's totally different. And as for the communication, and even during last year, we had a lot of cases We recall just a few of them to which media react, and we are trying to react to that. But also there is a lot of some complicated stories that are not obvious, and we are trying to bring that to media because now, most often I'm saying like media, when we get calls with the comments like, I won't give you a story. And most often we have to tell that to foreign media because we had some time in our work when we had to refuse to many of them because we can talk about the problem. We can talk about gaps, procedures, about the things that we are doing, how we are documenting all of that. Like how international community can help us, but we won't give them a story. We won't give them the victim who will tell in all the details. Like even if we understand this argument that somewhere on the level of international advocacy, it will somehow help. We have the live person here about the interests of whom we have to remember.
And also, except of work with like general public understanding, we try to work with professional communities, but remembering that these professional communities is a part of this big society. And we've mentioned that unfortunately, quite often we bring stereotypes to our professional life. Those stereotypes we get as part of society. Talking about the tools, within the last year and a half, we have this very dissolved understanding of communication tools. We try to use everything we think of, everything that's we have access to. Subway campaigns with banners, with brief statements, with messages people can read while moving on the escalator. At least start thinking like, what was there on harassment or something? Yeah. Where is the limit between flirting and harassment? Do I understand that? We worked a lot with leaflets for media community, for the survivors, and how can we work with that and separate leaflets about sexual harassment, rights of service women against harassment. We try to develop our partnerships. We understand that people who can require this information, they may be in unexpected places, and we work with different platforms. We try not to limit our understanding of where we can place information of that type. It's important to note, apart from social media in general, is this is one of the key sources of communication, but for us, TikTok became, we were so surprised that we started using it, we prepared to enter TikTok. The first video with clarification on sexual violence took so many views, and also comments were there. We did not know how to respond. People said, I had that 8 years ago. I had that like when I was 8, 16, 3 months ago, I had that. You don't understand. And hundreds of comments. Do you need to respond? What to do with this? And how actually to even realize like what's happening behind the closed doors and how much work there is to be done for all these comments to be for this to relate to satisfaction and justice, not just about horrible cases that is kept silent. One of the biggest challenges is these informational precedents. Like Zakarpattia, or we had the story with that parties in Kiev. When we had requests for comments, and I understand that for lawyers it was hard. It is hard to comment cases where they're not the party. They do not see the materials of cases, but we recommend, highly recommend, and we ask lawyers working in Eurofem, support and experts. We ask to comment why, because this is the well, first you have a chance to bring it from digging in the basket of dirty laundry of the survivor, push it to the social problem, like shift it, maybe some procedural gaps. Why happened like it shouldn't have happened, okay? Not necessarily speaking of what's happening in this case, but about your experience, how you do see the investigation of these cases. But apart from that, if this is not commented by an expert with gender-sensitive prism, someone else will do it. The majority of media, they find those who are ready to comment, if it's a lawyer, but a person has no understanding what gender-sensitive approach is. Not all media will be stopped. You have a comment, you have an opinion, okay, it's an expert, good. If you don't comment this, someone else will. Of course, before we recommend someone to our lawyers, before we recommend our lawyers to comment it, we check if this is an actual media, who is that? But mostly these are people who can get the comments, we recommend to do it. Just to summarize, informational background. In the first part of the day when we were in the shelter, everybody knew how many missiles were hit. We're listening to panel, but everybody knew how many were hit. And this constant dispersion we live in, you know? The situation affects, and what affects more, that we still have the full-scale war going on. And in this informational background, it's really hard to live with the violence. That's what I told about it. It seems like the scope of violence is overwhelming. It's growing. It's covering you with your head, you know, like a blanket. And our brain is trying to create a protective mechanism and create a picture, but it's not with me. It does not relate to me, to my relatives. It's far away. It's not about me. It's not my thing. And these constant losses and information about violence in the context of war, if something else is added about sexual violence not related to conflict, it becomes hard. And still, this attempt to think that threat is only where the Russians are, professional community has to decode it. And we have to understand that we have to be very interested that after the victory, for us to be able to feel that now it's safer. And that we finally pushed Russians away from our territory, we can feel safe. But for that, we have to talk right now about sexual violence, which always was in the shadow, and a threat for society in general. It was like behind the closed doors in dark streets. It took place, or like in public places in various forms. It was always there, but it was closed, concealed, and stigmatized. And our joint work, and after this forum, of course, we need to create conditions for us after the victory, breathe out and feel that it's much safer for us here than it used to be. And we're so strong now that we are ready in any case, in any situation, to start defending the survivor, because the statement, it's not that clear, it's not about us, we have to forget about it. As a society, we feel the consequences when you believe in something that it's not like that clear. I do believe that this joint work to protect all survivors, us as society, from sexual violence, this will be the part of our big satisfaction. Thank you, Irina. Thank you so much. 6 missiles were hit, Kinzhals, 1 rapist got a verdict, so we just have to keep it in our mind In our criminal justice paradigm, we only have 6 minutes for questions, and this is like one question or two. Give me a chance to understand. Who wants to ask a question? Microphone. Okay. Thank you so much for this interesting panel, Alexandra Holub. I'm gender advisor of Marina Bardina MP, and we talked a lot about communication inside the criminal process. There is communication when we, as activists, lawyers, we have blogs and various materials when we want to inform the public on certain legislative amendments, or when we are advocating because we want these changes to happen. We can communicate with international partners as well. Quite often we have certain de-objectified information. The PGO's information on CRSV is not giving personal data, but some details can give this emotional response. The age of person, how it was committed, by how many perpetrators. Is it appropriate for the public materials, to use this de-objectified, depersonalized information, but emotionally colored? What % of our message can be dedicated to these details? The background, why we have certain amendments, or why the help is important. Thank you. Microphone is coming to the next question, please. Who wants to answer this? I'll be brief. So we have to understand what is the aim of that, and understand that this is message for the media. We have to understand what detail is in the headline. This is the responsibility. You have to take it in your blogs. Blog is a personal responsibility. You just have to understand the consequences. If you have a similar aim, then highly probably that the key message will be lost. We communicate via blogs, not just with the audience in Facebook, Instagram, or elsewhere, but with media as well, because when there is an issue, we check the key accounts of people communicating, and we check the comments and posts. If you take the responsibility, if it's supporting the aim, yes. If not, not. It depends on the style of blog. Thank you. Next question. My name is Mikhailo. About Zakarpattia, I just want to ask the judges, lawyers. There is the background. The information was quite unclear, and from the MPs from Uzhhorod City Council, there was also rape of a minor girl in the end of 1980s, and grandmother came to her peers saying like, oh, she was raped. So we either file a complaint, or you just collect money, and someone has to become her fiance. The social pattern. You just have to understand the background. This pattern is dominating. With the personal data, it was a hype when the journalist publishes the information. So I have a question. When we spoke of the first instance, the appeal, and the male defendant, the lawyer, how was he representing the interests of the raped girl, because the boys were also minors? I like the remark of the judge from Kharkiv. In this case, I think the judges were not clearing those issues. But this judge actually is doing that properly. How to implement those standards? UFM is one of the professional platforms to implement those standards and to understand that such components as rule of law and respect to human rights should be integral. Thank you for this respect to us. So give us a chance to implement this thing. Roxolana, please. Thank you for the question. And a couple of errors in this case. And the key question was why the verdict that should not be published. It was published with the details in the Unified Registry of Verdicts. And as far as I understand, all those details were disclosed. So again, coming back to all that we mentioned, principles of communication, I think we can change it only by raising awareness, self-education. Interest to this topic, lawyers and judges and journalists community, it's important for them to be interested. And it depends on every person how this is communicated. If everyone taking part in this case at any side will ask a question of what is the aim, and remember about the interests of survivors, focusing on survivors' interests, this communication will be respectful and complying to all the norms without violating the dignity. It depends on each of us. I support Roxolana, so it depends on all of us. For the community, for legal community of Zakarpattia, if you take the laws of Sicily of 1970s, you know, they stopped functioning when these crimes against female sexual availability, these were the crimes against public morale. They were just organizing weddings and that was it. The story was over and the crime was over. Because this is not a story, but a crime. Thank you so much for this conversation. If you think about the roadmap that we are building, we may think of that we can create an algorithm for communication of lawyers, judges, prosecution, media, and NGOs and CSOs, which also trace and observe the topic and represent the survivors hard to communicate. For the survivors or people who suffered from this crime, to know where to go, to know that they have a lawyer, to know that there's a prosecutor, to know that what judges speak and think, that there are media who help and some media may do harm. And to know that there are people who, in each case, are defending the survivor with trust and respect. Thank you so much. That's what we all aspire. Thank you. Thank you. Thank you for this conversation. I remember the comment I received from one of my subscribers quoting, "I was so lucky I wasn't raped." I was so shocked of what she wrote because obviously this woman thinks, and so many women think, sexual crimes are so disseminated. It's not just their fantasy, it's reality. It's disseminated. The scale is such high that if you are not raped, this is luck. And just think about it. Not being raped is luck. So very drastic situation. Something that should be abnormal is like typical, and something that should be normal and typical, protecting health and sexual productive health, psychological, mental health. This is vice versa an abnormal thing. What to do with it? So that's why we gathered today, and I just want to have the head of Analytical Center UFM, Katarina Shunevich. She will summarize, she will present the idea on the roadmap on how to counter sexual violence that we brainstormed. Katarina.
Thank you very much. Hello, everyone. First of all, I would like to thank everyone for your work because during today, when you were working, Analytical Center Europe was trying to process the results, and I hope you can see that already. This is what we managed to do just today. Just imagine what we can do in a year. And for the beginning, I would like to say what we determined for ourselves and you also. Some topics that were key. First of all, that is reaction and prevention of sexual violence in general. That is what kind of problems, what can we do today? Next, it's prevention of sexual violence during conflict. Then we also had two important topics. The first one was reaction to cases of sexual violence in the context if the children are the victims, and the last and most important actually, or most important due to the fact that this forms our understanding how we react. This is communication of cases of sexual violence with society. So it was interesting because during different panels, we could hear 5, 6 key theses that were taking place, and they belong to each of the subgroup. First of all, the issue of the visibility of the problem and visibility of victims, and visibility of victims not in the context of actually the stories that were mentioned on the last panel, but the visibility of their needs and how we from our side as legal community and state in general can satisfy those needs. Next, approach oriented on victims. This was mentioned also in multiple contexts, and we will see how we are talking about next. Education and increasing communication. That is when we were talking about prosecution and law enforcement agencies in general, medical workers, court experts, and so on. So the next key direction is related to that. That is interdisciplinarity of education and interdisciplinarity of reacting to needs. For example, during the second panel, if I'm not mistaken, when we went to the shelter, it was mentioned that let us form interdisciplinary teams. Actually, in the on the stage of prevention as well, let us find out the teams and let us find out the problems that might emerge. And the next one, it's very interesting because depending on the discussions, is the issue of specialization, because somebody was talking about wide conceptualization, and we said that we all have to know what are criminal violations related to domestic violence, criminal violations, sexual violence, and somebody mentioned that let us create specialized persons who are going to conduct a pretrial investigation of such criminal violations. At least that is a very good talk for the beginning, and as a maximum we can see what we will have next. Now I offer to continue. This is the first thing. That's about challenges. It's about possible ways of possible solutions. So main accents that I am paying attention to is first, right qualification of determination of violations against freedom. And it's very important because people who are practicing, there's a lot of people who are practicing, like how different Article 153 and 54 are. So how can we defend the rights of victims if we as lawyers and women lawyers also cannot identify what kind of criminal violation was caused? And here we have the issue of collecting evidence and understanding what is voluntarily consent, because we've been talking about consent in times of occupation, not only during the occupation, but also the violation of personal freedom. And like we were talking that the issues of sexual violence existed for a long time, but if we say the number of violations against the things that are in ownership and the number of cases of violence, sexual violence, are totally different if we compare these numbers. And again, it's one more direction, it's one more problem that was mentioned, in particular the issue of, like, first of all, private or public prosecution. It has to be done only with the person. Second, do we have to transfer the burden of proofs to the victim, who I would like to remind you is not always a side of prosecution, so unfortunately in this, here you can't see that clearly, and I hope you will have access to that. We provided for the guarantees that should be there, and you offered those. Next, the issue of statistics. It is obvious that we have to get statistics on different levels and different bodies that we are representing, not only, and also like NGOs that are providing services to the victim. We have to unify the numbers because like different structural subdivisions or in general the bodies and citizens in the state should understand what number of violations is committed, and they should have mechanisms if, for example, the police refuses to register a criminal case. So one of them was actually offered today. Next, it is very important, the standards of Istanbul Convention is not only about improvement of procedure, but it's about criminal responsibility for cyber violence, stalking, and other things. That is incredibly important for us to create the framework with which we can move on, because without this framework, it is hard to react. And this is also the step that we can make together. Next is actually, I hope you can see now, sexual violence during conflict. It's the second group. That is actually what we mentioned. Like, first of all, it's approach oriented on the victims. It means that available and comfortable for the victims conditions during which we are collecting evidence. Our aim is, as it was mentioned already today, is not only to put responsibility on person, but also to help those people who survived violence. And here it's important to implement international framework provisions and documents. For example, we have a document from the Office of Formula Patton, which was mentioned on how to react to sexual violence during conflict, and the Office of the Secretary General told about the documents that they developed, and we have to make that from the national level to the local level. And so that in local and places we have this kind of reaction. Then a very important issue is to ensure the needs of the victims. And we are talking about the law of reparations, which was mentioned today already, and also the necessity of sensitivity of the different legal bodies, because they have to understand that they have needs of like housing, needs of satisfaction of primary needs, and then the need of justice. The next draft law is the issue of ensuring the issue to ensure the proper confidentiality of the victims in criminal procedure. And we were already mentioning the draft law, which provides for all the guarantees and which are necessary as of today, so that the victims take part in the criminal procedure on investigating sexual violence during conflict. Next, education has to be really scholastic, that is, cover everything, and representatives of the Ministry of Internal Affairs and the Security Service of Ukraine that can be involved on the pre-court investigation, and also those actors to whom the victims come first. These are the people who have to undergo the education in order to understand what are the peculiarities of sexual violence during conflict, how to determine that. Next, children. Again, that was the issue of the approach, victim-oriented approach, when we are talking about the third group. Can you see that, group number 3? When we are talking about children, this is also approach oriented to children-oriented approach. You are talking about the evidence from children, that is the evidence that they give, questioning application of green room. And also today we had a very interesting way offered as implementation of expertise, actually a recorded examination. This also can be a way, like, while we don't have necessary legislation, because we know that all the evidence has to be studied in court, it might be one of the ways of resolving that. But it's important for us to change our approaches and to use Article 15, as we mentioned, when we are talking about the military, the martial law times. And also in particular as for children, it's very relevant because in spite of that, in many cases, children are more sensitive. And also, secondly, very often children can have the experience of violence from their relatives, and the child automatically does not get the status of the victim, but representatives have to pay attention to that. It's one important step. It's the interaction between the criminal justice bodies and Ministry of Social Policy, in particular social services, because social services can be the subjects that can react to such cases straight away. But here again, we are coming back to education and to the necessity of conducting education in order to have complex understanding of the problem. Also, when we are talking about children, you can see in more details, and of course, we will send that to you, this information. I mean, there's one more direction number 4 that we were processing. That is actually the issue of communication. The main problems were the communication of the legal community and also people who are working in media, and maybe not always they are working with legal topics. So how these criminal procedures are being communicated and how we are communicating about sexual violence, because it is forming general understanding of what is happening in the society and also forms visibility or invisibility of different programs. So first of all, we have to determine the necessity of communication from the side of both bodies of pre-court investigation and court, those criminal procedures. Second is education for those people who are responsible for communication. Those might be speakers, reference, I mean, depending on the legal bodies that they are representing, but this has to be communicated so that society understands, first of all, what we are doing today already and what kind of challenges are there. And it's important, even if you represent the state body, it's not okay to keep silent about that. And also communication from the media side, that is to highlight in these problems, and not only problems, but also situations, cases, as it was mentioned on the previous panel, not the cases about the previous experience, but cases about what has to be done in order for this not to be repeated, how the person can understand that they also suffered from similar type of violence, and sharing best practices, best reacting, and sharing cases where these rights were defended. It's important for people to believe into the law enforcement system because the results of the questionings show that this trust is not really high. It's really briefly about the results. Here you have the example, but of course we will send you the full information about our actions, and we truly hope that these actions in 1 year will be implemented. Thank you. I want to thank our analytical center, in particular, Ms. Katerina Shinevich, and that is Hata for the fruitful work that they do, and also their experts of analytical center, actually the whole team of educational center and European support, Marta and Yulia Nikitina and Victoria Karpa, Marta Pavlishin. I'm afraid that I will forget everyone. Svetlana, they've been working on these documents. We will, of course, send it to all of you so that you can comment it. You can provide your offers, your proposals, and correspondingly, after you comment and provide your proposal, we will process all of that and we will send it to all the responsible parties responsible for its implementation. That is to all of you. So you can take part of responsibility on yourself in order to implement certain recommendations that we process together today. And at the end, I would like to mention that in order for you to have more motivation to work in prevention of sexual violence, in part sexual violence related to conflict, have professional deformation, it seems to me that soon this abbreviation will be used all the time. So I'm using the full speech. So we have founded your family board that is for representatives of legal community, depending on what field you're working on. Either you're like lawyer or the employee of law enforcement agencies or scientist, or you are the judge who creates precedent practices for victims of sexual violence. That is, it doesn't matter whether you're a student, lawyer, who and due to your initiative, you implemented certain educational programs and courses on victim-oriented approach, or maybe you're a lawyer working in legal authorities or local authorities. It's important that you're a representative of legal profession, and thanks to your voice and to your active actions, the approaches are changed, the system has changed, the attitude to victims are change. We would like to highlight that. We would like to show faces of these men and women lawyers who put a lot of efforts in order to change some things that are deeply rooted in our society. And our colleagues, they know that to change something that was processed for years, it's like to hit a really thick wall, and sometimes it's really hard to do for one person. Therefore, your family board on our website, we have the application that you can submit or nominate yourself, nominate your colleague to this kind of award. And every year on our forum, we will announce who is receiving that, who is receiving this acknowledgement of their efforts on prevention of violence. So you see the QR code here, you can follow it, you can get acquainted with the requirements. And I would like to mention that forming the requirements to the candidate, if you recall, when I presented the survey, we were asking like, who is the best like lawyer, for example, who is reacting to sexual violence, and we took into account opinions, and when forming the indicator. So please get acquainted, please share that, and thank you. Work. I heard, we are seen, we can hear each other, and also radio culture, which is our information partner. I think that we will have a lot of information materials about our today's event. Thank you to all of you who were here today. I won't keep you long. I invite you to have dinner. We have the dinner again at the top. I hope that it won't be as hot there as during lunch. There will be more fresh air. We asked to have such a dinner, not to have long queue, you know, so we can go upstairs and have communication, come back home safely, and bon appetit. And also, let us make a general photo. If you don't mind, please come to us, everybody.